All right. Welcome this afternoon to our county commission meeting. We're going to do a mic check for those that are on Zoom. Paul Jones, can you hear us? That's why we do a mic check, and I can see that yours says that you're muted, Paul. Is Paul the only one that's on? Well, his boss says that we can go ahead without him, right? Okay. I just don't want, if somebody else gets on, to not. Oh, there's Ben Van Noy. Can you hear us, Ben?
I can hear you, Commissioner.
There we go. Okay. All right. Tell Paul to get back to his office. We were checking on him. All right. Again, welcome. We do have two county commissioners here, myself and Commissioner Sakovich. Commissioner Gardner is not with us today. She and won't be calling in. So just be two of us. That puts us in a position where we have to be completely unified for anything to move forward. So that's where we're at.
As long as you agree with me, I will be unified.
I know, that's right. So as always, we start with a prayer, a reading, or a thought, meaning that any one of those three, if anybody would like to give us a prayer, a reading, or a thought, and then if anybody would like to lead us in the Pledge of Allegiance, we look to the audience to see if anyone would volunteer. Which one? The pledge? The pledge is taken. I feel like an auctioneer sometimes. Prayer. Come on up. Please tell us your name. That way we can put it. Yep, that'd be great.
My name's John Kirby.
Thank you, John.
Our most kind and gracious Father in heaven, we thy children bow our heads and give thee thanks this afternoon for the opportunity we have to meet and to function as members of a community, as government. We are grateful for these great leaders who we have elected and for the opportunity we have to discuss all these things that we've brought to this plate. We pray, Lord, that the Spirit will be in this meeting, that we may be able to openly communicate what our hearts desire in our minds. We believe that through thee and through thy guidance, we might have a mutual understanding. We pray for an amicable spirit to be here and that there will be no contention and that we can have a good meeting. We are grateful for all we have, for this great land we live in, for those who serve to protect it, and for those who have done so in the past. We're grateful for all we have, and we offer this in the name of thy Son, Jesus Christ. Amen.
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 I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right. It's my privilege we have a recognition of Miss Utah County, which is Lindsay Larsen. If you'd like to stand up. Thank you for being here. She's gonna speak to us a little bit, but I wanted to just tell you a little bit about her, and then I'll let her tell any more that she'd like to. Lindsay has been in Utah County since she was 4, and was born in. I'm really getting mixed up now. 4 years old in Lehigh, and she loves dance, as I can see here. She's been Miss Utah County now for how many days? 44 days.
Yeah, since August 12th.
Since August 12th. So she's pretty new to Miss Utah County, which. Congratulations on being there. I love, as I'm reading down through here, that she's a ballet. She's studying ballet at the University of Utah. I wish it was BYU, but anyway, University of Utah, but it's ballet. And I love dance. I love that you love dance as well, and you like to do that with children. I took a dance class at BYU, It was called The History of Dance. And I had a professor or instructor there that used to say this all the time, which I still think is true. We dance to live, and we live to dance. And I've always thought that's pretty profound if you think about it enough. It doesn't mean that your dance is necessarily ballet or ballroom, but there's always a dance in life that's going on, and we do live to dance, and we dance to live. And so movement is important, which is an important part of your initiative. And I think that's fantastic that you're here. So thank you. It's good to have you here. We're going to give you a chance to talk a little bit.
Awesome. Thank you so much. I really love that quote. I'm going to share a little bit about my social impact initiative, which is titled Move to Change, Changing Lives Through Dance and Movement. And it's all about helping people better their mental and physical health through dance. And so I recently partnered with the Utah County Health Department, and I have visited one elementary school so far in Utah County, and I'm hoping to branch out to more elementary schools. And I have also started 2 adaptive dance programs, which I run at Lehigh and Skyridge High School. And hopefully I want to branch that out further across Utah County as well. But I'm so excited to be here. I just want to say thank you so much for your support and allowing me to be here today. The Miss America organization and Miss Utah County is so important to me. Growing up, I really struggled with speaking in front of people, and I still get really nervous. I'm definitely sweating a lot right now. But because of Miss America and through competing in the Miss America organization, I have found this confidence and this courage to be able to stand on a stage and in front of a panel of judges and be able to eloquently talk in front of them. And it's truly because of this organization, and it's really changed my life. And because of the Miss America organization, I have earned over $10,000 in scholarship to go towards my higher education, which has been so huge. And so this program truly means a lot to me, and I really appreciate your support, and I want to help make this program continue on for years and years to come so that more young women like me can become confident and can be able to come up here and speak like I am today. And so I'm just so grateful for your support today.
All right. Thank you. Any thoughts, or Commissioner?
Just admiration for what you've done. Made me think of growing up as a guy in high school and afterwards, where do I go? How do I do it? And I was thinking all the impact that you can have with the schools that you visit, that people can be involved in the community in so many different ways and do so much good. And for that, I'm glad to see this. And we are sponsoring this, Commissioner Lee.
We're hoping to, absolutely. Yes, in the future, yes.
If we are not, we have to fix that.
There we go. Okay.
Well, thank you so much. That truly means a lot. Thank you.
Thank you.
Okay. Thank you. Thanks for coming.
Thank you.
And you can stay for the rest of the meeting. I wouldn't recommend it, but it's up to you. Unless you want to talk about water and, I don't know. There's no dance in that, anything like that. So, but it is part of a dance. Wouldn't you agree, some of you that are out here? Yes. All right. Okay. Thank you for that. We do have a public hearing, which was noticed. We'd noticed that before. And so we have a public hearing now to discuss the proposed addition of the land to the Rowley Agricultural Protection Area. And I will suspend the rules that we normally have so that I can second motions in this meeting. And Commissioner, if we could have a motion to open up the public hearing.
I would make a motion that we open public hearing.
And I'll second that motion. All in favor, say aye.
Aye.
Aye. Okay, we are now open for a public hearing. If there's any, a public hearing gives the opportunity for anyone to comment, particularly on this proposed addition of land to the Rowley Agricultural Protection Area. Any comments? Is there any online? I only see 2 attorneys online, so I'm assuming there probably isn't. Is there any hands up? No? Okay. Oh, wait 1 second. I just saw somebody else come online. We are now in the public hearing on the agricultural protection, the addition of land. Is there any comments? Still seeing none. Okay, Commissioner, we can probably close the public hearing.
Then I'll make a motion that we close public hearing.
And I'll second that motion. All in favor, say aye.
Aye.
Aye. We are now closed out of the public hearing. You will see later on our agenda a proposal. So with that now, we will build our agenda, and just for reference purposes, as you'll look at our agenda, the consent agenda has nothing underneath it. That's because we are going to hopefully put things in consent, which means that everything has been agreed to, ratified, approved, or whatever was put in. And if, in this case, if Commissioner Sakovic and myself, as we have looked down through these agenda items individually, feel like that there needs to be no further discussion, then we will just move everything to consent, except for the items that we deliberately hold and say we need to have further discussion on. Those then will be left on regular agenda for consideration for more discussion. Probably as clear as mud, but it seems to work. So with that, if we could start with items number 1 through 10. Are there items on there, Commissioner, that you would like to hold to leave on regular agenda?
I would like to go through 4 because there's 2 proposals to provide.
Yep, that one
burial
does need
services.
action, so
Yeah.
4 will be held. I'm fine with leaving number 10 on consent if it's consented to that we make the change in the suite number from 323 to 318.
Okay. Just need it. I can concur with that.
Okay, so we'll leave that on consent, but there will be a change in the suite number.
Okay.
Okay. Number 11 does need action,
It does.
so we'll hold number 11. How about 11 through 20? Any others?
Just administratively, there's signature blocks need to be changed. The names are not correct in a couple of those for
Which one?
2021, both of those. But otherwise, I can consent to the content.
For 20 and 21,
Yeah.
there's names that need to be changed on
Yeah,
that?
they have the clerk auditor as Amelia Powers or Gardner.
Oh, okay.
Minor stuff.
So if we leave that on, I'm fine with having those changed to the current clerk auditor. Leave them on consent. Great. Okay, number 22. That's the one that we had the public hearing for. Does that one need to be held for findings, Dave, or can that be left on if we want to leave it on consent?
I think you can leave it up consent for just adopting those.
Yeah, because we
Okay.
already had public hearing on that, I think. And
Yep.
so
Okay.
I'm fine with that.
So we'll just leave number 22 on consent with the adoption of the findings of the fact and conclusions of law and decision that is stated. And then holding number 23
Mm-hmm.
for discussion. All right. And I know that we need item number 24. What about item number 25, 26,
I
and
haven't heard
27?
anything on
24, 25, and 27 are needed. 26 is not.
Okay.
Okay, these are our closed meetings.
So strike 26 for the closed session then.
So then I propose that we strike number 26 and that we approve and set a date, time, and location for a closed meeting as stated in number 24, 25, and 27, and they be left on consent, if you're agreeable to that.
I'm agreeable with that, yes.
Okay. Okay. So Alice, do you want to run through our agenda?
You
Make
bet.
sense of it for us?
You bet. We're holding agenda item number 4, 11. Number 20 and 21, the only changes is to change the clerk auditor to Josh Daniels. So those are on consent. But then we're holding 23. And then for the closed meetings, we're going to hold closed meetings 24, 25, and 27, and striking 26.
Perfect, as always. Thank you. All right, so all other items that we did not hold are now consented to. Is there any public comment to those items that we had moved to consent? Okay, seeing none there. We'll move on to our regular agenda then. Our regular agenda only has a few items on there. The first one is item number 4, and this one does take action. It is for indigent burial services. Just so the public knows, if somebody passes away, they don't have family or any means. They have to be buried somewhere, right? And that's what this is about. Is that's something that the county does take care of, and so we have companies out there that bid on this service to perform that service for us. And so, Robert, go ahead.
Yes, Robert Baxter, purchasing manager. We only had 2 proposals, and the evaluation committee decided unanimously on Premier Funeral Services as their recommended choice.
Okay. Any questions?
What was the vote on the Kramer family? I don't know them. Just curious what the breakout was for number 2.
What do you mean?
You had a unanimous decision for number 1. I was just curious, what was the vote on number 2? Was there one?
Well, they all voted for the number 1.
Right. Did any of you vote for the Kramer family?
No.
None? Okay.
Okay.
Then that's it then. Okay.
So a motion to be in order then.
Make a motion that we adopt the number 1 as provided by the committee for the Premier Funeral Services because of the unanimous decision. That'd be agenda number 4. So.
Okay. And I'll second that motion. All in favor say aye.
Aye.
Aye. That passes 2-0 for that. Okay. Number 11, we have to set a public hearing. This is another public hearing to consider the request of Charles Ray Bettis to vacate a portion of 3200 West between River Lane and Spanish Fork River near the Palmyra area.
Yes, Commissioner Robert Moore, County Attorney's Office. Mr. Betts actually came to this commission meeting last week and made that request and also provided a written document that's attached to your agenda requesting that vacation. State law does require 4 weeks of published notice, which is why it's so far out. And so if you're interested in doing this and considering it, then I would recommend that you set the public hearing for the date that we provided, which would be November 10th, 2021. And then we will go ahead and provide the required notice by statute.
Does staff see any reason why we would not go through?
No, I think when I've talked to Richard Nielsen, it's a road. It used to be a bridge going across Spanish Fork River that was washed out many, many years ago, never been rebuilt. And I don't think there's an issue with this right now.
I'm wondering, should we, we need 4 weeks, do we, that calendar starts when, tomorrow or today?
We would provide notice later this week, yeah. So it would give us a little bit of time. That's why we kind of looked at about 6 weeks to allow us about a week to get it published, and then 4 weeks straight, so, yeah.
Okay. That'd be fine. Yeah. Okay. I'm good with that.
Okay. A motion would be in order then.
Then I'll make a motion, we adopt the public hearing to consider this request for November 10, 2021.
And I'll second that motion for the public hearing there on November 10th, 2021. All in favor say aye.
Aye.
Aye. That passes 2-0. So far we're batting 100,000.
Now, I don't want hostilities to occur up here, so I'm going to go with what you say. No.
Now to the one that everyone's here for. How about that? We're moving along pretty well today. Number 23 is to adopt an ordinance to amend section 6.04 related to the approval of water and sewage disposal facilities for dwellings and other applicable structures and uses. Robert, go ahead and give us an overview of that.
Just to remind you why we're here today. So in January of 2021, the State Division of Water Rights folks came down and spoke about water issues, particularly up Hobble Creek Canyon of Utah County. And I think kind of scared all in the room by saying that they anticipate shutting off water up in Hobble Creek Canyon, including culinary of water in existing homes. And there was that discussion, that revelation that came that day, I think took all us off guard a little bit. So the county commission directed staff to prepare an ordinance that can attempt to address some of the issues that were raised by the state. Again, the county's not the one shutting off water, it would be the state if they do that. And the state has said that the water is over-allocated up in Hobble Creek Canyon. So staff prepared that ordinance. We brought it to your agenda in April of 2021. The county commission referred that back to the planning commission then. It became a pending ordinance at that point. So since April of 2021, it has appeared before the planning commission. It has been debated there. I had a public hearing at the planning commission. We spent a lot of time discussing it. They made changes to it. Planning commission recommended changes to that, and I believe it was a 7-0 vote? I think it was, or maybe it was 6-1. 6-1 vote to recommend what's before you today. We also came back to the county commission and had a work session to discuss it. And then we were here last week as well to discuss this, and we're here today. Let me just real briefly mention what the ordinance entails, the proposed ordinance as recommended by the Planning Commission. Number one, and what the ordinance really does, it doesn't attempt to stop development. What it does is it puts people on notice of certain things. For example, the ordinance proposed requires them to sign a notification and waiver that puts them on notice of pending litigation, which has been pending for a long time in the Third District Court up in Salt Lake, related to water rights in Utah County.
Long time is how long?
40 years.
40 years.
35 years. It's just the 80s. And so that's been pending for some time. What's happened, though, is, and the state came and told us this, is they're moving forward now. And we've seen some evidence of that is the state engineer's office issued an order in April of 2021 related to Hobble Creek. Also, they hired a river commissioner for Hobble Creek in May of 2021. So things are starting to roll. Things are starting to happen. And ultimately, water rights will be potentially affected in the county and particularly Hobble Creek Canyon through this litigation and through the state. Again, the county does not deal with water rights other than requiring them. So, number one, we require them to sign a notification of that. That's the proposal. That'd be countywide. Number two, in the ordinance, which quite frankly was kind of already in our ordinance, if someone were to lose their water, we've had that happen before, the county has required them to replace their water. And so that's already in our ordinance now. This is kind of bolsters that a little bit and makes it more explicit that if you lose your water, you have to replace it. It makes sense, right? I mean, if you live in a home and you no longer have water to your home, that's a problem for that. Our hope is that never happens. That is our hope. And we try to do what we can to make sure it doesn't happen. But at the same time, it's really out of our control. That's the state that makes that determination, not Utah County. So the ordinance does, again, bolster that language to say that if you lose your water, then you have to replace it. That can be tricky. And we talked about this during our work session a couple of weeks ago. That can be very tricky, particularly of Hobble Creek Canyon. There's not a lot of sources for water. The third thing that this proposed ordinance does, as recommended by the Planning Commission, is if you live in the Hobble Creek drainage, then you are subject to an additional requirement. And that is because the state, again, is focusing in on Hobble Creek, saying that, quite honestly, they're one of the worst state issues well, one of the worst water issues in the state. That's what we heard. And that's scary for Utah County. I mean, as we've said before, our worst case scenario is anyone loses water and not being able to live in their home. So what the third thing that we're doing here is proposing is that if you live up in Hobble Creek Canyon, that you have to have either some sort of an expert, like an engineer or an attorney, who can determine and say your water is sufficient. And if you can do that, then you can build, no problem. If you can't or are unable to do that, then there obviously is a water issue you need to deal with. But really, that's more of a notice thing. So again, the notice is countywide, but this particular area has that additional requirement for, if approved, which require either an attorney or an engineer to certify that your water rights are sufficient so that you can have water even if the state were to affect that. I think what that does is it provides additional education to the proposed homeowners who are looking to build a home or remodel a home or whatever they're trying to do. That's what that intent behind that is to provide that additional education, and also so that everybody knows what the water status is at the time that they look to build their home. That really about covers what the ordinance does. It's not an ordinance that prohibits or stops development up the canyon. I actually communicated with the property rights ombudsman regarding this ordinance, and this was what he recommended. He mentioned to me that Wasatch County has an ordinance related to roads that are substandard and some issues related to that, and he suggested that I try to model something similar to that. So I've done some of that with this and tried to, as we and the staff worked hard, we met with the health department, with community development, and with Public Works in my office to try to come up with this. And of course, we went to the Planning Commission, and we've had a number of public hearings and others that have made good recommendations on some changes to this as well that we've adopted throughout that process. Did I miss anything, Bryce? I'll be happy to answer any questions too.
Bryce Armstrong, Community Development Staff. I think Mr. Moore covered it well. The only thing I would add is the reason, and Mr. Moore alluded to that the section is related to Hobble Creek is as part of this Hobble Creek area is subject to a water distribution system that was ordered by the state engineer of Utah earlier this year. That is somewhat independent of the adjudication. This is something that would address the issue more immediate than the adjudication will. The adjudication still has to go through its process, and so the distribution system is based on appropriation priority date, and that's why the expert requirement is in there to sift through that and to verify that, because it's quite complicated, and I think that's something that our staff is not trained to be interpreting and administering, and so that's the purpose of having that extra requirement, is to have a review of the underlying water right for a given structure, and as it relates to these processes that have been put into place or will be determined by the state.
And on that issue, let me just mention, there is a cost, of course, when you hire an engineer or an attorney to give that kind of an opinion. And we recognize that. And we've discussed that both at the Planning Commission level and also here. And as staff, we discussed that. I mean, that was a concern that we've had all along. But I think what we've looked at was whether that cost was better, especially if that engineer or attorney says, you don't have sufficient water and you need to get some additional water or do something different. So the property owners are on notice before they go and spend hundreds of thousands of dollars to either build a home or to remodel a home. It just makes sense that they're totally go with their eyes open, and that's what the expert is meant to do, is to provide that additional information. I realize it's a cost. I think we all do, and we wish it didn't have a cost with that. But we think that weighing that against the potential is, particularly for this area. Now, the hope is over time, the state will come back and say, no, we're all good, and we can take all this off, or we can modify it. I mean, your legislative body, you have the ability to change things, or maybe this isn't working right. after some point. This is our stab at it, to be frank with you. And when I talked to the ombudsman's office, I asked him, anybody else in the state's dealing with this like this? And he said, no. This is it. Now, there are some cities that have shut off water because of the drought, and they just stopped issuing permits altogether. That's not our proposal here today. Our proposal is to continue issuing permits, but through a process of education of the folks that are seeking those permits. And one other thing I'll mention, and you guys raised this last in our work session, is that yes, this only addresses future building. It really does not address those existing homes that are not seeking to remodel or seeking to build a home on their property. Though those existing homes, if they stay existing like they are, they can continue on for all time, and this will not affect that. I don't think we have the ability to do so. When they come in for a permit is when we have that ability to impose these additional requirements, if you decide to adopt this ordinance today or sometime in the future.
In the remodel, if there was no additional faucet sources needed to be installed or toilets or tubs, that would not require an engineer's statement because it would be just replacing a wall or a window or...
It depends, and if it's putting a shed in, for example, that would not require...
I'm just thinking of the residence itself. So if they had to add a porch or a wall was coming apart, they could replace the wall without having to come in for a separate engineer.
And the language itself covers permits, and so it depends upon what they're doing, whether that would engage them or not.
So the normal permit process that doesn't affect water directly then shouldn't require an additional engineer then?
Possibly. Yeah, again, I'll let Bryce address that.
Bryce Armstrong, staff. The way the proposal is currently worded, it says any structure that utilizes a water source. So you're adding a wall or you're remodeling a bedroom, and you're not adding any water hookups. The way the ordinance is written, it still would require this statement. I think the thinking is that home is going to be just as subject to having their water shut off than any other home up there.
Yeah, I can see the statement. I just don't want to see them be required to have an engineer in addition to identify where they are with water. Just simply a statement is all that's necessary. If they have any substantial changes to their home that would require a permit. So if there's no additional tubs, toilets, or water sources in the house being installed or being pulled out of the ground, it should not require an additional engineer to verify you have so much water.
The current ordinance doesn't contemplate that. It can be modified to do that. I think we need to be very clear because that can be somewhat difficult.
Yeah.
Someone brings plans in and they're replacing a tub. They're not adding a new one. So, we need to really be clear on that.
As long as
That's
we're
the way
not
I wanna go.
expanding what they're doing, is just replacement for age, that we shouldn't require a specific engineer unless there's something unusual about the design. But other than that,
So that would
that's an
require an
option.
amendment to what is proposed, because the current proposal, that would be required. Anytime a permit is required, then they have to go through this process. So you will have to change it if you want it not to apply to
You
an
have the ability
existing
to do that.
structure.
yeah, my feeling is if you're not drawing more water than you normally do, you're replacing something with something that's updated. A new wall is being installed, but it doesn't require any no faucets or will be affected. To me, it seems like that should not require a specific engineer review other than the normal permit process that's already in place.
And probably signing the acknowledgement and waiver. I would suggest you do that either way, because that's putting them on notice of the litigation, et cetera. But as far as the engineer goes, I mean, you could modify our current proposal that the Planning Commission recommended to, if it's a remodel, maybe it doesn't affect the existing footprint.
Right.
Then maybe that's how you address it.
Yeah, because I don't want to affect the homeowner in a way that's not necessary. To let them be aware that the water level is going down, that's one thing. If they have to tap in additional wells, that's another thing. But if it's no additional water is being tapped into because of replacing things, modifying things, putting in a new wall, a window, then to me, they shouldn't require an engineer specifically to let them know that you have or don't have enough water.
If that's what you want to do, that's fine. Yeah,
Does
absolutely.
that make sense?
I see where you're going. Can I take it one step further?
Please.
And first off, thank you and the staff and everything for working through this. This was a recommendation to the Planning Commission from the commission, knowing that we've got some issues that we're trying to work through. And so, a lot of the people that are here, we are their direct representatives. They don't have a mayor or city council, and so this is a very serious matter for us. Not that any of the others are not. It's just that this is a serious matter enough that I think we need to make sure and get it right as best as possible. I know we're saying we're taking a stab at it, and it can be modified, but I just want to make sure that we understand what we're seeing before us, and I appreciate your comments, but maybe to take it a little bit further. So in that case, we're talking about a home that's in place that's already up there right now, and they want to do some minor modifications, and they can, and this here does not require them to go through that process, nor if the water starts to, it does say, I don't know how clear this is. As I'm reading through it, it always throws me in just a little bit of I can hear some of our county attorneys saying, well, I don't know about that, which you guys are. But because it's, an owner of a lot or parcel, well, they're owners of lots and parcels. And so as long as it's really clear that we're talking future and not past, I think that's a lot better. But the way I wanted to ask the question was, what about somebody who has purchased a lot? They have no building up there. They have no structure. They purchased a lot with the anticipation of building. And in purchasing that lot, they also purchased along with that water. There or not, I'm not sure how that all works, but still. And then they come in and they ask for a building permit. And now they have to go through the process, and it puts them in a little bit in a cloudy area because they're wondering if they have water or not. And of course, you have to have water to live there. Obviously, you can't just say, let's just get the evaporation to work. But anyway, so how do we deal with that? That individual has purchased a lot, they've purchased a certain water rights, and now are we going to ask them to go through this process?
Go ahead. The way the proposal is written, yes, it's triggered by a permit utilizing a water source. And so if a person is in an approved development that went through a process, the most recent one we've had was in 1999, the cottages. There's a number of vacant lots in there, so they're still eligible. There's people that are trying to build currently. Those water rights that were approved in 1999 were looked at that time and determined to meet the requirements. Now we're understanding as part of this distribution system that some of those rights may not fall in the right priority and may be subject to being cut off. Doesn't mean they don't have water, it's just they don't have the right priority. And so the thinking behind that is that that new home could be subject to having their water turned off next year or 5 years from now. And so the idea is to make sure before they make that investment that they have that verified by an expert, and then they can make that determination if they want to move forward. And that expert may find out that they don't have that water.
But they've already made the investment, right, with a certain understanding.
Sure, purchase of the lot, absolutely.
Purchase thinking that they
Absolutely.
already have this. And so it goes now to my second question with this, and that is I want to know from your perspective what the county's responsibility is when it comes to water, particularly, and what your office views as our responsibility to it, because I hear over and over that the county is a party to maintenance agreements, that individuals bought lots and with an understanding that there's a certain agreement that the county is a party to maintenance agreements as well. And so what is the county's responsibility?
Let me just be as direct as I can. The county has no responsibility related to water up in that subdivision that you're referring to. The Maintenance and Open Space Agreement specifically mentions that the developer shall be the one who provides the water. Never does it mention the county actually providing the water. The reason why the county is a party to the agreement is because the county is the beneficiary of that Maintenance and Open Space Agreement. So the county requires the developer and to do the requirements that are within that agreement, including obtaining the water. The county itself nowhere in that agreement has any provision that says that the county shall provide water. And so the county has no obligation here. I think what we're trying to do is trying to help the folks up there to know what's going on before they, like Bryce said, before they invest the money here, because it's not going to be the county that shuts off the water. We all know that.
Right.
It's going to be the state if they do it.
Right.
And so going back to your first question, those are the people that were, every lot owner up in Hobble Creek probably bought it with the intention of building at some point. And that may not be the case in all situations, but in many of them it probably is. We want them to know before they try to build and spend the hundreds of thousands of dollars on building a structure, a home, etc., that they know what water they have. And maybe the water they purchased is not sufficient. It'd be better to know that up front than, like I said, a couple of years down the road and the state turns off their water.
Certainly.
And that's what we're trying to deal with that. This is a situation where we were dealt this. The county was informed of this in January. Up until that point, we were, I don't think we had an idea that the water was as dire as it really is. It wasn't until the state came down, I think Commissioner Lee even talked to the state, and that's what got him here, because we discovered that this could be an issue. And that's when the county now realized there's an issue going on. Again, not us turning the water off, but the state itself. And so we're trying to help the property owners to be educated when they make those financial decisions about their home. And the worst thing that can happen is for someone to lose their water. We all acknowledge that. I think everyone in this room would acknowledge that that's the worst thing that can happen. And we don't want that to happen for anybody. We want them to understand what they're getting into when they decide to build up in Hobble Creek Canyon.
Right.
Beautiful canyon.
I guess the only other thing I would add is, as you're aware, and most probably the people in this room are aware, that the county doesn't provide these type of services out in the county. That's the reality of building out in the county, is you need to provide these services generally on site on your own. Usually, in most cases, it's a well and a septic tank. In certain instances, including up in Hobble Creek Canyon, there are types of developments that require, due to the size of the lots, a central water system. But those are systems that are run by a company, a water company, not the county. And so the reality is people, property owners that want to build out in the county are providing those services through means of their own, whether it's through their own well and septic tank or through participation in a homeowner association and a water system.
So if I could kind of maybe summarize, we'll get to comments as well. This proposal here is forward thinking in the sense of development into the future.
That's correct.
And if the commission decides to modify, we can modify so that it does not affect current homes on minor adjustments. And I don't know what minor is always, what does that mean by minor or certain adjustments? And we could probably even adjust it to those, who have purchased property, meaning that they don't have to go through. I mean, we can still notify and say, hey, there's water issues up here. We don't know what they are, and if they purchased a piece of property, they don't necessarily have to go get a lawyer or an engineer to sign off on it if they've already purchased the property and they already have supposedly water there. We can still inform them. The states, there's issues going on up there, but if somebody was to come brand new, this would apply. This could apply. Is that fair?
If that's what you want to do, absolutely. I mean, my suggestion, if you're going to go down and have those kind of modifications, that you would probably continue this ultimately and allow us to make those modifications and bring them back to you so you're comfortable with them before you finalize what they are. Because there's a lot of people that I think would like to know what those modifications say before you finalize them. So that's my suggestion. We don't have to do it that way. You could approve it with modifications and we'll just put it in here, but it will allow us to make sure that
my biggest concern is that we don't make it onerous for particularly those who already have homes there. If they have to move a wall or replace a window, a tub, a floor is falling out, they're trying to fix that. They shouldn't require another engineer to verify they have enough water because they're already there. They should be grandfathered in.
Yeah.
And my only suggestion to that is that if you're going to do it that way, that's fine. but that at least require them to sign off on the notification, which we require everybody else in the county to
Yeah,
sign
at
off.
least give notice
That
because
way they know that there's water issues up that canyon.
when did the
I
state
think
say that?
everyone knows there's water issues, but yeah.
When did the state say that Cobble Creek was one of the worst cases? Not because they're bad people; they're wonderful people.
No,
but
it's
the water issue.
That's been our discussion with them.
How long has that curve been showing the water going down? I'm curious about that.
That I don't know.
And I think what that reference was to multiple factors, mainly the over allocation of water rights in Hobble Creek Canyon, and then that's exacerbated by drought and such, seasonally.
So the droughts brought it to the forefront. The drought we've had for the last 3 to 5 years.
Yeah, I think that exacerbates it, but I don't think that's the underlying issue. The underlying issue is the over allocation of water rights. Before we move on, I guess let me make sure I understood the comments. I heard two things, maybe looking at a modification that would not require the expert statement for, number one, existing homes. And I think the best way to define that is just if there's an existing home period, you don't have to do that. Even if you add an extra bathtub or an extra bathroom, that doesn't increase the amount of water required. The states define that as 0.45 acre feet per domestic unit. And so that amount isn't based on whether or not how many bedrooms you have or how many fixtures you have. And so I think the simple way to address that is just got an existing house, then you're not subject to that.
Okay.
So we can work on that.
So you could add a room and then have an extra bathtub, and it wouldn't require.
That doesn't affect the amount of water
a
you
specific
need.
engineer review. Okay.
Yeah.
Other than the normal permit process.
The other thing I heard Commissioner Lee reference was perhaps not having this apply to those who have already have a platted lot within a development that was already went through an approval process and determined to meet the requirements at that time. Is that kind of what I'm hearing? Mm-hmm. So in that case, then there's dozens, if not hundreds, of vacant lots that are in a platted development that went through an approval process that would qualify to meet that criteria. And if a person came in for a new home on that lot and it met all the other requirements, then this would be crafted so that it would not be subject to those enhanced requirements for an expert statement. Is that kind of what I was hearing?
Right. Because I mean, like you've mentioned over and over, we're not the one turning off the water, and if we're not the ones turning off the water, and the state's the one that's doing it. And I always find it. I think they should have a responsibility to do that, or the homeowner should have a responsibility to kind of find out where that's at. Part of the problem I have is when I'm reading this, if I'm reading it in the future, it makes sense. If I'm reading it with what we already have now, I have problems with it. And that's the reason why I think you're seeing some modification in language where we're talking about that, because if we have water problems up there and just on a practical basis, if I'm reading down through it and all of a sudden they fall out of that for one reason or another, and then we go back and we say, now you're required to go get water. And if there's no water up there, it's like trying to get blood out of a turnip. I don't even know where you get I don't even know how that works unless you start to, buy somebody else's, right? Or something of that nature. It really becomes problematic.
And we acknowledge that there's a potential impossibility on some of these but that's not us that's creating that. Right. What we're trying to address is you can't live in a home without water.
Right.
And so
we do kind of create a little bit if we write it in like this, though, don't we? Because if it's written in there, we're starting to say, "Hey, all of a sudden you're below it now. Now you have to go out there and get that."
Well,
buy that
that's already
water.
in our ordinance. I mean, right now, if you lose your water, you have to replace it. So if that happened tomorrow and somebody lost water up Hobble Creek Canyon, we had the same thing happen up Provo Canyon, where a subdivision lost their water, and we automatically went after and started requiring them to fix their situation. So that has happened before.
We have that in an ordinance. I think that would just naturally apply if you lose your water. Yeah. I mean,
you're in violation of our ordinance by losing your water.
Yeah,
and the building code requires that. I mean,
absolutely.
Those are basic
Fire
steps.
code.
Right. Yeah. Okay. Yeah. There we go. Now
all
we're
those things
on
all
the fire side. I get
all
it,
those things
reasons.
required. So this is just making it more clear. It's supposed to be doing that. But if you want to have those exceptions, that's not a problem. My only suggestion on both exceptions, both for existing homes and for existing platted lots, is that they still sign the acknowledgement document.
And all they're acknowledging is what? Just that
they're
there's
acknowledging
water
that there's
issues?
a lawsuit going on and that they're building at their own risk. Yeah, absolutely. because we want them to know that there's a lawsuit pending that will apply to particularly their property. And that's important to know that. We want to be on notice, that they know that they are building with full knowledge that there's a lawsuit pending and it could affect their property.
For what reason? Just notification, just in case?
Or should we just put simply a statement of
Well,
there's
it
a
helps.
lawsuit?
It absolutely helps.
And would go to existing
It
homes?
helps them. It helps when they sell their property to the next person, that they know as well that there's a potential, and that's important. It's
So
important that people know.
I
there's-
agree,
that's
but
been-
there's different kind of notices, right? There's a notice you put out there and say, we want you to sign this, with an affidavit that you recognize these things. It's a protection measure.
Right.
And there's an information notice too, right? There's one you sit out there and say, hey, here's what's going on up here. We want to fully make you aware. We just want to we want you to realize that this is going on. You're signing off basically saying that I've been informed.
I think the way this was drafted, the way I drafted the notice, was tailored after. We have a provision in our ordinance related to avalanches, and you may know this.
Yep.
We don't prohibit someone from living in an avalanche zone, but we require them to sign a notice that they live in an avalanche zone, and that that they're aware of that, and that if they're doing it at their own risk. And this is kind of the same concept. We are letting them know that yes, there's a litigation here. The state's involved in that. The state's running that, and it has the potential of affecting their water. And if their water gets shut off, it's at their own peril. It's at their own peril, and so that needs to be sure. And also when they sell the property, I go and I build a house and I sell it 1 year later. You want the next property owner to know as well,
Sure.
and that's important.
I just don't want us to do like we did in the avalanche zone where we say you can't be in your cabin from Christmas
And we
to
don't have
New
that.
Year's.
That's not in here.
Well, we did that. I'm just saying that I just
Right.
don't. That's the attitude I don't want to have. So
Ms. Bryce, again, I think the other component of that is to protect the county too. Unfortunately, if the worst case scenario happens, there are going to be some upset property owners, and they're going to come to our office first, and they're going to say, you guys issued me a permit in spring of 2022, knowing that this was in place and this potential was there. And so, excuse me, that's something that we'll be able to rely on to let us know that, we made that full disclosure to them and that there was a certain risk that was associated with moving forward.
and I get that too. We have a fiduciary responsibility to the county, and I get what that is. On a protection basis, it is kind of, and sometimes they become a little bit at odds. We're representatives of the people on one side. We have a fiduciary responsibility on the other side for the county, and those sometimes we have to kind of navigate through. And so I get that. I get that, Bryce. That we want everyone to know. We don't want. If we know that there's an oil spill or whatever, some landfill up there, we want people to know what they're
Absolutely.
getting into. And I don't think anybody would balk at us saying, "Hey, there's issues up here, with water."
Should we have a notice sent to all the plot owners as well, separately?
And we haven't explored that idea.
Just let them know that, hey, this is going on. The water has been, level has dropped dramatically over the last many years. And
I suspect that if the state starts shutting off water, they're going to be getting some notices. Yeah.
are they
but
actually
as far
shutting
as
off
us,
water, or are they diminishing the level of water?
They have actually threatened to shut off the water. Yeah, absolutely.
Threatened but not done yet.
Well, they said that they might shut off some this year, secondary water, but next year, during that meeting, they said culinary water will be next year.
Yeah.
I mean, I was here, and that's why I was like, wow. I think as an attorney representing the county, and and these good citizens that paid a lot of money for their homes and lived in relatively peace,
Yeah.
and now all of a sudden the state's saying we're going to take away water, but
Yeah, there's a phrase in real estate law where you're supposed to, when you have property, it's supposed to be the quiet enjoyment of it.
We have notified the river commissioner of these proceedings, all these meetings we've had. There was an invitation to him to come to this meeting. I'm not sure if he's here or not, but some of those answers probably best answered by the river commissioner or the state.
Well,
he did speak at the planning commission, just so you know.
In your conversations with the state, would you please let them know that it should not be full value water levels now, and then the next moment later is complete shutoff? Is there a diminished track that they're going to follow, or is just simply turn the spigot off?
You know, I don't know what to tell you about that. I don't control what they do. I know that they're looking at options too. I don't think they're trying to stop, turn water off. I think they're trying to figure out options as well. One of the real problems with Hobble Creek is your source. You only have one source. And whereas other canyons have sometimes multiple sources. And so Hobble Creek is kind of unique that way, at least somewhat unique. There's probably other places in the state that have that uniqueness to it as well. But their water is more limited into how they obtain it, whereas other canyons can have multiple sources.
Okay.
And with it, I think we should, with the change in the code that they're going to add to it, I think we all should pencil together a notice for the owners that have land that they in that canyon but haven't built, at least so we can send to them, this is coming up, you should be aware, so they're not going through the process of time, money to develop and engineer a home out there and may have missed all this information.
Okay.
Any other questions from you?
All right. We're going to take some comment on this, if you're all right with taking
Please,
comment.
yes, yeah.
And so if you would practice civil dialogue with us. And so most of, if possible, our rules state that comments should be addressed to the bench, not necessarily to individuals or anything of that nature, and hopefully stay on topic as much as possible. I know it's hard, and it's but we're let's talk about this. And so please, I know the line's already formed. If you, how many people, just out of curiosity, how many people would like to make a comment on this so I can get a feel? Okay, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12. Okay, I'm seeing 12. I'm going to write that down. We are going to we're going to go for 2 minutes. Yeah, go ahead and put the shot clock up there. That way it gives you kind of an idea for where we're at. And it wouldn't hurt anybody's feelings if somebody's already said what you're going to say and you said, well, I don't need to stand up there and say it again. Same thing. Please, and please state your name just for the record.
Hi, thanks for letting me speak. My name is Joel Farah. I'm here to represent my clients. I was here last week as well. I've learned a little bit more about this. It's unfortunate that I only have 2 minutes because they had, I don't know how long to gather their thoughts and do their thing. So I'm going to try really hard to get this done. I'm not an attorney, so I apologize for not fully understanding this. But I've only got a few minutes or just a few seconds here to figure this out. But essentially, I've got some notes here. Number one, my understanding is this is not a notice. This is a declaration. It's a waiver. And it puts anyone who signs this in a position where they're waiving their rights to defend themselves for their water. My clients can speak to that a little more specifically. They're the ones that talk to their attorneys. But my understanding is this is not just a notice. And secondly, I'm the guy that has the building permits, by the way. The second thing is they're not just asking for us to prove we have enough water. They're asking us to prove that we have the correct water rights that are dated correctly so the state can't take them. So basically the county is now inserting themselves in and trying to do the state's job of actually verifying whether or not we actually have valid water rights. That's beside the point. That's the state's problem, in my opinion. So before my time runs out, I just want to say that I would strongly urge the commission to vote no, not to go back to the drawing board. We have projects right now that are both up in the mountains. I have 2 permits now, not just one. I have 2. The other one's in Provo Canyon. I don't know why I'm getting this notice for Provo Canyon, and I have to elaborate on that. I needed just a little bit more time, but they're holding both permits, and they're asking us to sign and provide both the same amount of information, or at least on the one in Hobble Creek, they're asking us to actually prove that the water rights are valid. Not that we have enough water, but that they actually have the correct date and all these other things. So that's problem number one. Problem number two is right here, part 1 in the ordinance, it says, Health Department approval, water and sewer of the Utah County Land Use Ordinance is hereby amended, including the appropriate renumbering and reformatting of applicable subsections, blah, blah, blah. They're calling out the health department as part of this process, but we were not given any notification. We were actually given approval by the health department, still not given any notification that we were going to have to go through this process or sign anything or do anything before we were given our permit. I've been in there for months waiting on these permits, months. We've been working on both these projects since last year, coordinating with the health department, with the building department. Never was there any mention of this, not all the way through the summer. I have approvals from the health department from this summer. Nobody said a thing to us about this. We had absolutely no time to gather our thoughts or present a case or anything. I received notification on the one in Provo Canyon this morning. They said, oh, by the way, your permit's ready, but your client's gonna have to sign this waiver to pick up his permit. I had no idea that this actually applied to Provo Canyon as well. The biggest problem is that I don't feel like we've been given a chance to deal with this at all. I don't feel like the planning department has taken enough accountability. We don't understand why they don't go to the health department and notify them that this is going on. Everybody who wants a building permit in Utah County has to go through the health department first. There's no way around it. So, but every time I bring up, why didn't you let me know this when I was at the health department? The planning guys just say, well, that's the health department. That's not our department. And so we've been put in a really bad spot. I think most of everything else that I can say can probably be covered by the other folks that I came with, but am I missing anything you think? Let me just double check one thing. I think just the one note is that we don't understand. We think you should vote no because we don't think that the county has any business trying to determine whose water rights are valid. That's the state's responsibility in our opinion. But yet they're sort of putting us to the task on that in order to get our permits. They're sort of holding these permits hostage for this information. The permit, one more thing, the permit in Provo Canyon is for a new structure. It's for a new building. He's had a will serve letter from North Fork Water for at least 12 months. We don't know why I haven't even had a chance to notify that client that this is a problem, but yet we're trying to rule on this ordinance. Like I said, I received this information this morning. He's had zero chance to defend himself, to figure out what's going on, anything. And so I think there's way too many problems in this ordinance to just make modifications to it. I think that the planning commissioner, whoever is responsible for coming up with the ordinance, needs to start over and try harder to protect the people that already have residences, that already have properties, and at least protect the people that are in there with permits, and take responsibility for the fact that they didn't let the health department know that this was a problem. We could have dealt with this in a much different situation. I probably wouldn't even have to be here if I would have been notified when we were at the health department instead of right before we were about to pick up our permit. They literally did this on both of them. They said, by the way, your permit's ready, but you have this. They let us know at the very, very end. They had opportunity to tell us and they didn't. And that's all I have to say. Thank you.
Okay. Obviously, our 2 minutes is kind of out the water a little bit, so blown out of the water.
I will do my best to talk fast.
We'll try to deal with it. We want to be fair as much as possible.
My name is Jenny Lambert. I own a property in Upper Whitmore. I purchased this in July of 2020. The property nobody had been there for a number of years. They had a second floor deck that did not have a roof cover over it. So imagine the snow sitting on that after years and years. It was leaking down into the kitchen area where we had lots of water damage in the roof, and I have pictures of the roof coming in. Rodents had taken over the house, so we had to go in and pull out all the carpeting to get rid of all the mouse droppings. So 2 days after I bought it, I hired this company to go up and try and put this back together again. We By September the 22nd, we have emails with the health department that we were working on the septic system. We went through this entire process for over a year now. We have been working on this. Finally, we had to lay off for the winter because you can't build in the mountains in the winter. They wanted a topographical image that you can't do in the snow. So we couldn't do things for a few months. Spring came around and we started working again. All the way through this process, we have paid the fees. We have done everything that the county has asked us to do. Jumped through every hoop. They called us a week ago Monday and told us that our permit was approved. Then, after that, then they said, oh, and by the way, we'll give it to you if you sign this notification. I have spoken to 2 attorneys, one just as of this morning, and both have said, do not sign it. It is not a notification. It is a waiver. You are waiving your water rights forever. It says in here that it will encumber the land so that my children who inherit, if we ever choose to sell it, this will go with this. Nobody's ever going to buy that property. So it's basically valued at nothing if I sign this. It also states on the second page that if we lose water, they have the right to pull back our certificate of occupancy. Let me tell you, if we lose water, what I would do. We'd get up early. We live nearby, so it doesn't take us long to get to this cabin. We would go up there, and I still have electricity, and I still have propane, so we have air conditioning and heat, and I have a stove. We would go up, spend the day. We would ride the ATVs. We'd call a company to come up and put in a porta potty and stack up on bottled water and hand sanitizer. We would still go up and shoot some archery and lay in the hammocks and listen to the breeze and listen to the birds, and then go home that night. We could still use that cabin. But because if we don't have water, they're going to pull this so that we don't even have a cabin anymore, and you're giving them the right to do that. I feel like they talked about whether we were grandfathered in or not at our last meeting, because they said you didn't turn the permit in until, I don't know what it was, July or whatever. This was after April. Surely the septic system is part of that process. It says right here, you can read, it tells us right here, and I've been emotional, so now I can't read it. It says, no residence shall be used or occupied, nor a permit issued, therefore, until a potable water supply facility and sanitary sewage disposal facility has been approved by the Utah County Health Department. That is part of the process that we worked on for a long time before we ever got to submit it. Mr. Moore wants to pretend like they're on our side. They're not on our side. This is actually very damning to sign this. It's very hurtful. Throughout this entire process, nobody ever said anything about this until after it was approved. To me, it looks kind of suspicious, like they didn't want us to know. They could sneak it through if nobody knew. It's not right. I'm asking you to deny this. It needs, I'm not saying we don't have water issues, but this isn't the way to fix them.
Could I get a copy of that letter? The one
Which
you're talking
one?
about, the notification letter? The one that you said?
Absolutely, the notification, this is
Yeah,
the
the
waiver.
waiver.
Absolutely, it has my notes and scribbles all over it, but you're welcome to it. That's what they're asking us to sign. And even to get the letter from the engineer, I actually don't have a problem with that. I think it makes perfect sense. It should be part of the process. The problem is that it wasn't. It wasn't. And right now, I have a cabin that is open to the world, literally. It's open to all the critters and the snow. And I don't have time to close it up. And so they haven't given us time, and I believe it. They intentionally did not give us time to get that final step. It's going to take us more weeks than we have to go to that final step to do this. This cabin that I purchased was built in 2005. It is 16 years old. There's nothing new about this. It's had water the entire time. This is the kind of stuff that you hear about that goes on in this country right now, but I had hoped that Utah County was better than this to treat people like this. Thank you so much for your time.
Thank you. My name's John Kirby. I'm that dear lady's son-in-law, so feel bad for her. I just don't want to reiterate too many things that were said, but I was pulled into this just to help analyze. I do a lot of analytics for my job and for the military. Thank you, everybody, by the way, for being here and for your service. Even though we may disagree with some of the people in this room, we're all citizens, and I appreciate that. They say it's not the county's duty. Then why are they doing it? They say it's the state's job. Then back off. If we can't get a building permit from our county because the state is going to say something about the water rights, then put a notification, as Commissioner Lee said. I have a note here. Simple. You fix this. Have someone sign and acknowledge when they get their building permit. How hard is that? But yet, we're not going to have a cabin because the snow's going to take it out, because we can't get it enclosed in the limited time that we have before the end of the year, because they've held this according to the state, not the county, who has any jurisdiction over it. But the county gives the permits, and somebody's trying to appease somebody in the state and get this passed. I watched the video for last week when the attorney and Mr. Armstrong was asked by Ms. Gardner, will they get the permit if they sign these two things? And Armstrong says, yeah, absolutely. And then the attorney gets up and says, no, it can't until it runs the due course. Gentlemen, you were elected by constituents like us. I love this country for that. I actually had one of your signs in my yard, and I won't say who, but I don't want to push terms, but I appreciate this. I appreciate that you're here. I've listened to you speak and ask questions to them. I appreciate your wisdom. I urge you to deny this so that we can get our permit, so that they can fix it. All they've asked in the video last time and today is, well, we should sign it and move on. We should approve it and move on. Why be so hasty? Why cause issues when you could make blessings? Deny it, please. Give us our permit. Thank you.
So if we could, anytime there's a clap like that, I have to speak up. If you would, please not do that, just for the purposes of decorum. And the reason why, and I need to explain, is because I don't know what the opinions are. Some may be for, some may be against. We want to make sure that we have a safe environment for anybody to go ahead and voice their comments without feeling like there's something going on that, one side or the other. If you would, I'd appreciate it. Go ahead, sir. Your name?
My name, Richard Eddington, Lot 23, Hobble Creek Cottages. I'm here representing my wife, Carrie Eddington, and myself. I would like to state I've only just recently become aware of this issue and only had a couple of days to try and digest all the documents and information presented to me. So I'm doing the best I can with limited time and resources. This year, approximately 20 improved lots were marketed and sold with the understanding that water was available through Hidden Creek Water Company, of which we pay a monthly standby fee until we can connect to their water service. Prior to purchasing our lot, we were provided with a recorded document between the Hobble Creek HOA and Utah County that water for each lot is available to service each lot. We believe that we did our due diligence in researching these properties. Utah County is one of the parties of the cottages maintenance and open space preservation agreement, where the developer and the owner of Hidden Creek Water Company agreed to supply each of the 35 lot owners in the cottages with 2.95 acre feet of water annually. Utah County should honor the terms of the contract or enter into negotiations to adequately meet the minimum residential requirements for fair use. Only recently, we have been informed that building permits have been on hold. An ordinance is now being presented that effectively targets these 35 properties with the requirement that in order to build our homes, or for existing homes, we must have an engineer show that there is an alternate qualified water source. There is only one water source for these properties, and the county is proposing to limit available water or shut it off entirely. This ordinance effectively renders these properties unfit for their purpose and renders them without value. No reasonable person would have purchased property without water availability. Hobble Creek is a watershed for Springville and Mapleton. Springville and Mapleton have alternate sources of water and appear to be unrestricted in developing properties, further drawing resources from this watershed. This ordinance unfairly targets a small group of people in one area of the county and effectively denies them fair use of their property and livelihood. We will not sign a waiver of our rights. I urge the members of this commission to vote against the proposed ordinance and find a more equitable solution. Thank you.
Thank you, Richard.
Yeah, I'm John Barry from Fallbrook.
I remember you now.
What?
I remember you now.
Yeah. Okay. Can I? Okay, you starting. Okay. I decided to come up right away because what that gentleman said is very close to what I have down. I'm also a lot in the cottages, and with an expectation that we are already approved for water, already stubbed for water. We've been paying $3,000 for the last 5 years since we've owned this lot for water service. We have been working with the county for the last 12 months to finalize our plans, and we'll be ready to submit our building permit in the coming weeks. However, just like him, like last Friday, I heard from a friend that our building permit was at jeopardy, and I had to call the county to confirm it. And by the way, I had just met with the county the day before and talked about all my plans. They didn't mention it. We're quite shocked when we heard about the building permits. We're not only on hold, but seem to be unattainable, like he mentioned. There's and more actually confirmed. There's only one water source. We can't put in another well. There's no springs. So like he said, it pretty much renders, it pretty much creates an impossible to obtain approval through these requirements in the text amendment proposal. And if it should pass, it would render our lot unbuildable, worthless, even though it had been declared as buildable for the last 21 years. The county would be effectively reaching into our pocket and stealing it from us. We paid for a buildable lot. It is not fair to suddenly render it unbuildable. Instead of enjoying a dream home in Hobble Creek, we would be working with legal services to recover our losses. So we would appreciate you to seriously reconsider this amendment and try to make something that's fair for all those development and properties who already have been approved by the county.
Can I ask you a question, John? Because I've heard a couple now.
Yeah.
So one of the things that I proposed on this, along with Commissioner Sakovich, is that if you already have a lot and you've already gone through the process of purchasing it based off of water and probably your soil tests and whatever you have to go through, that was one of the things that we were contemplating. Contemplate. We haven't. There's no vote yet, right? So you would be in favor of that? Is what you're saying?
Well, of course. I mean, if you're going to allow me to, if you're not going to hold my building permit because I'm already grandfathered in a way, because I just don't happen to have a house on my property.
Right.
Everything else has met the requirements that have been laid down for the last 20 years. Then of course, I mean, as long as you're going to give me my building permit, I'm happy. And by the way, a notification I get, a notification that this is all going on, but don't add other stuff to the waiver.
Thank you.
Carol Ferguson, Cottages, Hobble Creek. I did want to say something about what Bryce had said about hundreds of lots, and it was referenced here. All of the lot owners in the cottages have been paying water fees monthly ever since the lots were sold. So even when they were resold, the people were paying. Also, it would appear that if we are having these restrictions, our property taxes should really be going down. So you're going to be losing money. I can relate to how Jenny Lambert feels so emotional. My husband and I have worked very hard and saved very carefully, been very frugal so that we could build our retirement home. We looked all over in Cache Valley, Salt Lake County, Summit County, Utah County, and ended up purchasing in Utah County because of the maintenance agreement. The very first paragraph in the maintenance agreement does say that the county is a party to this agreement. It does not disclaim anywhere in there that that doesn't mean we're a party to any water. We did our due diligence and checked, and we felt comfortable purchasing property. We came from Virginia. The water issues were a shock to us. I mean, we know that this is the desert, but we didn't know if you purchased property that had water on it, it wasn't your water. But because that's the way it is in Virginia, if you purchase something, it is your water. These people are not going to be able to prove their water rights. We cannot prove our water rights. The owner of the company, it appears, has never proved beneficial use to most of her water rights because she keeps getting extensions after extensions after extensions. So if the owner of the water rights that are put in a well is not proving beneficial use, proving the water exists, that it's not just paper water, how can you expect ordinary citizens to do that? We did have the expectation that the county, since the county was a party of this, then it was safe for us to purchase the property and put our life savings into building a home. Hidden Creek water is our only source of water. There is no more water. You can check with the state and you can check with Springville Irrigation Company. No more water is available. And to require the cottages to build a community well that has enough water in it is it's not doable. So it's really shocking that that would be a requirement that you would be making for the citizens in our community. And getting an engineer to sign that you have enough water, I think that happened for Backcountry Estates, didn't it? The engineer signed off that there was enough water, but it's the same water well that we are on. So now they're saying there's not enough water. There's got to be a better way to do this so that reasonable expectations can be met when people are investing their lifetime savings into property like that. The county did know in 1999, when the cottages was built, approved that these issues existed. If you go back and read the minutes in 1999, a lot of people brought issues up about the water. They were concerned about water, they were concerned about fires, all the things that we are concerned about. We never would have purchased property in the cottages if we had not known that the county was going to claim they were not a party to this agreement. In fact, in the November 16, 1999 minutes, it states that there is an attorney who sent a letter to the county concerned about the litigation of water rights. And the county's, what it says in the minutes is that that's not a reason to deny an application. 21 years later, you can see it was a reason to deny an application because perhaps that water is just paper and not real. I told you we felt secure in purchasing the property because of the county being a party to the maintenance agreement. No disclaimer saying that did not mean water. The maintenance agreement, Article 9, states that the CCNRs were approved by the, would have to be approved by the county before they were recorded. And then 13.9 of the CCNR state that the maintenance agreement is incorporated as part of the CCNR. It also states that 2.95 acre feet of water annually for each lot, as others have stated here. The county is a party to the agreement. It says that in the first paragraph. There is no disclaimer disclaiming anything in there. Nothing that says, but that doesn't mean water. Oh, and the county had to know what was in both the CCNRs and the maintenance agreement. The maintenance agreement was incorporated into the CCNRs, and in the upper left-hand corner on the front page of the maintenance agreement, it says that to send the recorded document to David Shawcroft, the deputy county attorney. So I think we're reasonable people. I don't think we go to extremes one way or the other. And we did think that the county was a party to this because it says, very first paragraph, the county is a party. So
Carol, can I ask you a question?
yes, sir, you can.
So in your opinion, what's the solution? Because you're saying on one hand, there's no water. And if there's no water, then how could we be continuing to build up there? And if we, I mean, the only control that I know that the county has up there basically is through a permit, right? So,
Right.
And land use ordinances. Those are the two areas. And so what's the solution? Because if we don't do anything and we just say build away, does that make the problem worse?
I don't know, perhaps the solution is divide equally what real water does exist in the Hidden Creek Water Company well. The only water that I'm aware of is the real water, or the 13 shares of Springville Irrigation Company that have been put into the well. But there are a lot of water rights in there, but it is my understanding, it appears that those water rights are all under protest. And because of just what you're saying right now, it does not make sense that county, the rules were made to protect the watershed and to protect the critical environment that is up in the canyon. And there are restrictions on CE1 property. It doesn't seem like it's prudent for the county to be going and making exceptions or doing text amendments to those things when the dude ranches were being discussed last week. And Janice Reed asked Mr. Shawcroft if a permit was required for a dude ranch. The response was, but that would have to be determined in the application. Or even reception centers, changing it for reception centers. You don't have any control over people smoking when they go to receptions. And a lot of people that smoke just throw their butts out, the cigarette butts. And
Thanks for clarifying that.
And
Make sure it's in the record correct.
that's a hazard because we'd all be burned down before the fire department could get there. We did have the expectation that we had water, or we never would have bought that property because we read the maintenance agreement, and that's what it seemed to be saying to us.
Okay.
Thank you so
Thank you.
much for your time. I
Okay.
really appreciate your service.
Thank you.
Could I speak out of order because
No, you, wait, wait, I,
sorry, go ahead. Go ahead.
yeah, let's try to keep it in order. I think that it's,
Hi, good afternoon. My name is John Tusting. I'm here with my wife, Karen. Like a few of the parties that came before us, we recently purchased land in Hobble Creek, cottages, same suppositions. We believe we were purchasing land that was buildable. had an approved water source from a licensed, state-licensed water purveyor, that's Hidden Creek. Had no reason to think otherwise. Still don't really know that there's really a true problem. One of the things I haven't seen in any of the documents presented is a true problem statement that's been generated to describe what this issue is, nor any kind of acknowledgement of how it got to this position. So we talked about over-allocation of water shares. If that is a major contributor, which it sounds like it is the major contributor, not the drought, not global warming, an over-allocation of water shares, then I'd argue that there is some culpability and some responsibility on the county's part to do right by the people that live in Hobble Creek. I do thank this group for their service and their time. I think that you are taking this seriously. It's refreshing to see that we have government officials that actually recognize problems instead of just kind of skirt around them. You are taking this head on, and I appreciate that. In reference to the proposal which is being presented, I, again, like a lot of others that came before me, didn't have a lot of time to process this. I've gone through a lot of documents that have been sent to me to try to glean what kind of context this falls into. It does seem as though we're trying to fly this airplane at the same time that we're building it. That usually doesn't end very well. I do agree with previous speakers that this does need to go back to the drawing board, that it should be rejected in its entirety right now as it's written. Commissioner Lee, I do appreciate your comments, and I agree with them that if you have a plat that has been previously approved to build, you have an approved water source, you should not be held to the same restrictions and requirements to have to prove that you have some alternative water source available, which everyone has stated, it doesn't exist. We don't have Bill or Melinda Gates in our community. Unfortunately, if we did, maybe we could make something happen. We're simple people, we're not wealthy. Like others here, we picked this community because it was a very attractive community. We love Springville, we love this Utah County. I've seen water issues where I come from. They've been existing for the last 50 years. Typically, it's managed through controls that are really simple. It's you have allotments, you have allocations, you have, when necessary, you restrict use. You have odd even watering days if it's irrigation. In the state of Utah, currently you've got about 30 acres, I believe, per day that is being converted from either ag or raw land into residential. Residential use basically accounts for about 5% of the overall water use in the state. So that paints a pretty clear picture of where most of the water goes. This is a drop in the bucket as far as the amount of use of water that's being presented for these cottages, for residential use. It's a drop in the bucket of the overall water that's available. I appreciate your efforts to better manage the water and try to get control of where it's being used. I think it's laudable, but this proposal is not the way to do it. This is the wrong solution for the right purpose. What you need is the right solution for the right purpose. That's it. I thank you for your time.
Thank you.
My name is Janice Reeb. I live in Hobble Creek Canyon. I served as secretary on the implementation committee for the new priority system of water distribution. And so I would like to take the opportunity to clarify a couple of things. The county has used the date of April to try to solve this dilemma in the benefit of the people, because that's when the state engineer, who has the power and the authority, issued an order saying that the water would be distributed by priority dates. The best water in the system, and it's not just Hobble Creek Canyon, it is all the way from Hobble Creek to its deposit in Utah Lake, its drainage into Utah Lake. And that's what the adjudication is all about, determining who actually owns the water, because it is over allocated. So what the county has done, what Dave and Bryce Armstrong and those who have been involved, is to try to put the people on notice that they do not have the power or the responsibility of trying to decide who gets what water. So what I would like to propose as a solution, possibly part of one, is that there is no more water available to the people who live north of the Bartholomew Pipeline, which is a municipal source. Those people would have to literally truck in water if they were not able to meet the requirements of the county. The good news is, however, that in that well, Hidden Creek Water Company well, that's what, 5 plats, subdivisions depend on, pardon me, has a priority date of 1851. There are 52 acre feet of water in that well that could possibly be distributed if there were negotiations between the county and the state. And one of the reasons that there is such a problem is the state and the county don't talk to each other. And so when we're talking 48 lots in just the subdivisions that depend on the well, that is, if you do the math, which I'm terrible at, that's what, 1 point some odd acre feet per household. If the state were to know that they weren't going to be sued because of this process, because that's what they are also concerned about, everybody suing everybody because there isn't enough water, then it might be possible for there to be some accommodation made because the people in the cottages were promised in their willing to serve letter and their documentation 2.95 acre feet of water. And that is to accommodate another 1.5 acre feet because it's such a high fire area. So if there could be some solution and negotiations made there, everybody's needs might get met because 1851 isn't going to be shut off. It's because 1892 or 1887, which is Upper Whittemore, that's a problem. But I think that this approach is an appropriate approach. The county has to defend itself from the situation that they can't fix. They are trying to put people in a place where they understand what's going on. And as a taxpayer, if the county gets sued, we all get sued. And we wind up paying for a problem that might be better addressed, knowing that part of the water in a well that can't be replaced will not be shut off because it's the most valuable water and the highest priority. Regarding Upper Whittemore, those waters, we brought in map after map to show how it was a continuous flowing system of water. And we did not, and we opposed building 40 new homes up there. When the county says we can't control the water, the state is doing that, that's correct. But what we can control is honoring the CE1 and CE2 statutes that say that the purpose of those statutes is to protect the watershed, not just for the people in the canyon, but everybody, Springville City, Mapleton, et cetera, because that's the watershed for all of them. And to put the word commercial into conditional property that brings more and more people up to damage the watershed is a poor idea, and that's something that will be coming to you. Hiring an engineer or an attorney to certify that the water is available is just putting an extra expense on people because the engineer will go to the state records and certify the water based on the state records. An attorney would do the same thing if he were a water attorney. And the state is not going to certify that their rights are correct. That's an impossibility. It won't, it's a step that does not need to be put in place. I really, really appreciate the approach that's been in place. I too love Hobble Creek Canyon, and I too care about my neighbors. And I do believe that this ordinance ought to be sent back, not scrapped, but sent back to be looked at in a different light now that there's more understanding about what a priority date actually means and how, if the county and the state were to collaborate and the 1.45 acre feet of culinary and household water has to stay in place. It's not because you all have been collaborating to deny people their building permits. It's because that's what the state requires and that's what the county requires for year-round occupation. And the state and the county law says if that water isn't available or if it isn't replaced, that the people can't live in their homes. It's different in Upper Whittemore because it's seasonal and only 0.25 acre feet are required for seasonal occupation. And Lamberts are correct. They are in a position where they have fallen between the chairs. And to push forward something to accommodate people who are in that position is, in my view, not solving the problem. Again, I thank you. I know I didn't mean to jump ahead. I'm sorry I didn't see you.
Thank you. Dion Barron. I live at 3 Meadow Drive in Hobble Creek Canyon, Springville. Signing a waiver isn't a solution. It just pulls the rug out from under us in doing what we need to do to protect our water rights. You know us well, and we didn't just start coming here in April. We've been coming here for 3 years. And one of our main contentions is please don't change the zoning from CE1 to CE2 that allows new building and new changes what people can do on their property. But nothing, we've never been able to get the county to stop changing the CE1s. That was to help the water. The county was told, we found today, 40 years ago, that there was problems that there was an adjudication process going on. There was problems in the water. That was 20 years before the cottages got approved. The county might have known, but there was no document that I knew. I only have this recorded paper here regarding the cottages at Hobble Creek, signed by Hidden Creek Water, and it's recorded as a county document that says she has enough water to provide 2.9 acre feet of water. This is a document that was recorded. The county didn't say, hey, engineer, you come and make sure she really has the water. You let it get recorded. You let it become part of our maintenance agreement. When I say you, of course, it was the other commissioners before. But the government that is supposed to protect us, because they got a notification, but they didn't do their homework, now wants to put it on us as homeowners and lot owners. And pulling the rug out from under us, saying, you can't do anything about it now because you've just signed a waiver, was a death sentence for all of us. I urge you to vote no against this and be our representatives and help solve the problem and not make me solve the problem by taking my right to build and then my right to have neighbors away. Thank you. Yes.
Dion has never been called dramatic, but very well. Thank you, commissioners, for the opportunity. And I really appreciate the opportunity to maybe go over 2 minutes. 12 people given 24 minutes to express their life. I appreciate the fact that you gave us the ability to do more than that.
Tell us your name.
My name is Russell Pearson. I live in the cottages, recent transplant to Utah County. In the discussions today, just a couple of things I'd just like to clarify. In my opinion, in this agreement, Maintenance and Open Space Agreement, which there's been a little discussion about, Utah County's name is all over it. And not just in means of accompanying the agreement, but by means and I would even say by regulatory authority to enforce the agreement. So the concept that Utah County has no culpability in this agreement, I think, is underwater. None of us would like the district court to make a decision on that, but in my opinion, that is in fact the case. Certain water rights were guaranteed to people that bought property or are currently buying property or trying to develop. I bought a house that's 17 years old, so I don't have the big issue. But I have nearly a guarantee of nearly 3 acre-feet of water per year. I will never use 3 acre-feet of water per year on 1 acre. I mean, I'm not going to use it. However, one way I've thought about this is that we can conserve this water if we don't use it. If we give up those acre-feet of water, they will certainly be given to somebody else who will then use them. So in a backwards way of thinking about it and backing into conservation, one way of being sure the water is conserved, which I think is the bottom line in the end game in all of this, is to leave it as is, at least in the cottages, because there seems to be a large amount of water that has been guaranteed. Some of the comments that have occurred to me today, or some of the things that have occurred to me today, is just some of the quotes that came from Bryce Armstrong in a letter that he sent to somebody who's building or would like to build a home in the cottages, and I think they're appropriate. They're forthright, and they really hit on something very important. Let me just go through a couple of them. Any source of water for a domestic use, including a replacement source. That's the first time I heard that concept, a replacement source. We all know we only have one source of water, at least in the cottages. We have the one source of water. So any replacement source needs to be of a permanent and perpetual nature. This agreement is a perpetual natured agreement. It's saying that we will have those water rights perpetually, agreed upon by the person who held those water rights and then gave them over to the development. And as I said before, Utah County's name is all over that agreement. Permanent or perpetual nature needs to be potable as determined by the Utah Health Department. Agreeable. I think that's a wonderful concept. Any existing dwelling, and this gets to some earlier conversation, any existing dwelling which has its water source reduced or eliminated below the required amount, which could only be done by the state, would need to provide evidence of a replacement source. We don't have a replacement source. We need your protection, and that's why so many are here today. We need your help to deal with the state of Utah so that we don't have to come up with a replacement source. The main intent of this provision is clearly make property owners aware of the need to obtain a replacement water source in the event of a reduction or elimination. And that's been discussed today also. The intent is to make us aware. Now, as the meeting goes on today, we hear more about this waiving of rights and water rights, perpetual water rights. We're waiving them away to get something else. We're giving up those things which we have yearned for, those things which we've sacrificed for. I'm a 63-year-old broken down construction steel worker, and I worked my whole life to get here. And I worked and put everything I had into that home. Then comes the nice part. This is a difficult situation, and I agree, and I appreciate that. This is a difficult situation. And this proposal is not intended to solve the problems related to the, and get this word because this is important, over allocation of water rights in Hobble Creek Canyon. The people who live in Hobble Creek Canyon should not have to bear the burden for the over allocation of water rights that somebody else did. Now, it may have been somebody else's father, it may have been a grandfather or grandmother who allocated water rights throughout the canyon, and there are not that many acre feet of water. So we come to a crossroads. How do we work through it? I don't know the answers, but I can promise you this. The approach that's being taken now, the CYA for the state and the county inability to kind of work this thing out and figure out what has to happen, is disturbing to the people who live there. And that's why they showed up today. There's more I wanted to get to, but I think those are the main points that really interest me. We bought into a perpetual water source, and we're guaranteed under a covenant saying this will happen perpetually. And now we're being told, it may not, and just be ready for it. I'd urge a rework of this entire agreement. Go through it, figure out a way. There is water there. We just heard a wonderful lady tell us there's more water there than we probably think there is. And I know my personal property, we have more water allotted than I'll ever use. Thank you for your time. I appreciate it.
Thank you. So according to my count, I've got two more. Is that accurate? Yes, 1 and 2.
I was going to see if I could steal one more minute. I did 2, but if I get a third minute, if possible.
Do you want to go before me or after?
I could be right now really quick. This was for Solution. This is John Kirby, sorry. Solution. In Upper Whitmore, it's seasonal. Too many people live there more than 180 days a year. Make them stick to the rules. Secondly, there are more shares than lots in Upper Whitmore. There's plenty of water. And then the third comment I was going to say, and everybody has reiterated it, that we urge you not to do this. We're probably the only ones that are in a time crunch before this winter. If you deny it today, we can hopefully get something closed in. If you don't, you table this and we try and figure out the wording. For lack of a better word, we're hosed. So, thank you.
Okay.
Thank you.
You're welcome. My name is Ann Diamond, and I also live in the cottages. When we were probably we built our home about 4 years ago, and the first thing we were told after we bought our lot was that we were in a drinking water source protection zone and that we would not be able to build on our lot. And when we went to the county and just said, why was this not on our lot, and in county records of being in a drinking water source protection zone, they said, we don't have to tell you everything. And I was like, what? I don't think that gentleman's still working over there. Let's hope not. But anyway, what happened was Jonathan Berry, who's also given his 2 minutes worth, he said, send me everything you can. He's the one that found the mathematical error that put our lots in the drinking water source protection zone. After figuring out how many gallons per second, minute, hour, day, you're supposed to divide by a number, and they had multiplied, which meant Hidden Creek Water was spitting out 11 million gallons of water per day. And it's really 221,000 or 250,000 per day. So that being a mistake that was on the records for 20 years, close to 20 years, I'm just wondering what other mistakes there could be. The state water rights records have a disclaimer stating that there is no claim that the records are correct. It appears they can't prove the Utah water right if the owner of the water right hasn't proved beneficial proof. So it seems like there needs to be somewhat of an overhaul, but we were in their position trying to get dried in before, and thank heavens Commissioner Lee came to our rescue, and we were able to do that. But this process
of getting a permit, and even after Jonathan Berry came up with a solution, it still took us over 4 months to get a septic tank permit. Septic tank, not even a building permit. And it was one monstrous hurdle after another. And so I just think, why are we building more homes in Springville City? If up in the canyon we can't build homes, is that a bigger water difference? They get a different water source. It just seems like we're being told that we can't build, or we can't build up there when we have one source. That's it. We have the Hidden Creek. We aren't allowed to dig a well on our property. We aren't even allowed to set up a collector and collect the rainwater out of our rain gutters and have a secondary, water source at all. So we're kind of stuck. And to me, if it's not on a county record where it can be put in some place where a title company could actually see, whoa, did you know that you were in a drinking water source protection zone? Or did you know you might not have water next year? That's an issue that here we are working with the county and going through all the things, all the hoops and everything, and then this gets sprung on people. It's just so, not too many people have, $100,000 to $200,000 to purchase a picnic ground for their family. Thank you.
Thank you. All right, I have you as the last one.
You
had yours as well. Okay, I probably miscount, so we'll do you as well.
You want to go first? Okay. I'm president of the Springville Irrigation Company, and you people probably don't understand the watershed up Hobble Creek Canyon. Okay, first off, there's people that have bona fide shares in Hobble Creek Canyon water rights. Okay, and them water rights.
I'm gonna interrupt. I'm gonna make sure and just direct your comments.
Okay, I direct them to you, whatever.
Yeah.
Anyway, these people have water rights in the canyon. They have bona fide shares. Okay, in the 1979s, late 79s, and the early 80s, the state went up the canyon up there and started giving out water rights with no bona fide research or anything else, and gave water rights to a lot of people. At this time, Springville Irrigation Company, Mapleton City, and Springville City started putting protests against them. And they've been protested for almost 40 years. And finally, and they didn't just do this, the state didn't do this, they also did it all the way up the Wasatch Front. The state seen they had a problem, so they went up and they put a special master to take care of the problem up there. And so they started up north and worked their way down, and they came to Hobble Creek Canyon. And a lot of things have happened up Hobble Creek Canyon. All these waters have been under protest on it. Now they're trying to solve the problems, and we're under litigation trying to solve these problems. And I think what the county's doing here is a very smart thing, to let the people know that they could lose their water rights. Now, the state's seen they had a problem. To solve this problem, to help solve it, they've put a creek master up the canyon and they're chopping them off on priority dates. So what I'm saying is, if you say you have an 1892 priority date, and if we don't have enough requirements at our dams below, at that time, you will be cut off. And that's where it's been up that canyon since the day one, okay? You're cut off on it. So these people that up there that have an 1892 right and have this claim that they might have punched a well, which the state gave them to, put it in, they're going to lose their right. Now this year, the state didn't do culinary water. So if this source went to a home, they didn't take it off. But next year, they are shutting them off on priority dates, the people that have those rights. Now, you people that live in the cottage, you have a kind of a protected source. Tracy Tanner has 13 shares in our company, which is an 1851 right, and so there is them 52 acre feet of water rights that she has, and we're in negotiation with her right now for maybe something else on it, but right now the negotiations are going on it. Okay, so what I'm telling you, the state, you as a county, be real smart not to give any building permits up there whatsoever, even if they've been issued prior to this or whatever, because they could lose some water, okay? I'm not saying it is, but they could possibly lose their water rights. Now, if any of you have got questions, I'm more than happy to answer the questions on it. The state river commissioner was going to be here today, but he had another problem, couldn't make it here today, but he was going to tell you the same thing I'm telling you. They will be cut off next year if they're not an 1851 right early on it. Now you got to remember, us as the irrigation company, we're trying to protect our users up the canyon that have bona fide shares in our company, and we got to protect Mapleton City for their Mapleton Irrigation Company, which delivers water to Mapleton City, and also we deliver water to Springville Irrigation Company, and then there's people below that have water rights too on that creek that flow clear to the Great Salt Lake. Okay, so there's a lot of water rights in there that is involved in this. And then you people say that you looked and seen that you didn't have it. All you had to do is get on the state website and it comes up there, and if it's a water right that you claim that you have has a big protest across the top of it, it's under protest, okay? And it's been under protest probably for 40 years on it till we can get this problem solved up the canyon. And I'm hoping to get it solved. I'm tired of spending money with attorneys on it, and I'd like to see it solved up there. But right now, there can't be any more building up that canyon because there isn't the water source, okay? Because we have to protect everybody downstream. You people don't understand that. There's a lot of people downstream that have these sources of water that we're trying to protect too also on it. So this protection is a good thing the county's doing to say, these building permits should stop until things are resolved. Now, any questions?
Well, the questions will come from here on this side. If they want
Okay.
to talk later, that's fine. So I got a couple questions for you. What's the solution if we have over allocation of water? And I'm talking about the solution from your opinion on those that are up there right now that have already purchased lots, that have already purchased homes. What's the solution?
Well, right now, the people that have homes up the canyon, I think we could get that pretty well covered with their sources. But the new ones, no, because there isn't the source, there isn't that water right there yet available on it, okay? You got to remember, this watershed up there produces a lot of water. Even when we're not drawing water out of there, that whole Hobble Creek Canyon in the left-hand fork is produced by springs. Everything is produced by springs. It comes up in that valley right up in there. And if you put wells in, then she don't produce any more on down the stream. And then during the winter months, it produces all the spring rights, all of Springville City's rights that are down for their culinary water down below on it. So it's a very critical watershed up in that canyon there where we're talking about on it, on the thing. So there is a solution, and the only solution I know of is push a pipeline up that canyon to, if you want to have more building going on up the canyon. But right now, there is not the water, okay?
Right. So are you talking about homes that are existing homes and those that have purchased lots and have also
The ones that have
already paid?
purchased lots and didn't do their due diligence, which I'm saying, they could be in trouble, okay? That's all I can say right now on it. The ones that have purchased and haven't built, I would be very careful on building a new big home up there in that canyon right now, because it's all under litigation right now, every bit of it.
If they've purchased a lot and they've been paying on the water currently, you say that.
Well, you're talking in Hidden Creek Water Company. The only company up there is Hidden Creek Water Company, and their Hidden Creek Water Company, their only source that's an 1851 right is their shares in our company.
And
Okay?
you're negotiating right now to try to find a balance. Like that one gentleman said, he probably has more water. Are you negotiating in the sense of trying to find water for everyone up there?
No, we're not negotiating that. We're just trying to resolve the problems on these people up there that claim they have water rights up there on the thing. And we're probably going to have to go a balance some way or the other. But right now, I'd be very skeptical on building anything up that canyon until the water rights are resolved on it, okay?
You said that this notice that it's under the litigation on the state website. Do the owners of the land have access to that? Did they get that? when they
Anybody
signed
can
the
get on that
contract?
website, Water Rights Division, and look it up, and it just tell you. And if you got a claim, say you got every claim up the canyon in this division right here starts out with 51. That represents Hobble Creek Canyon and the valley below it right here.
I'm just curious how many real estate agents that were selling lots up there knew about the website in the first
Well,
place.
I
The
can
buyer
tell
would
you what
probably
happens
not
right
know.
there with real estate people. We get calls every day at our office down there saying, does these people have a water rights? And we tell them absolutely no. But you got to remember, you're real estate and you're trying to sell it. So you're looking out for your pocketbook. And so they don't tell them nothing, okay, on it. That's the trouble we got on the thing. They don't tell them. We've had people come in later and say, well, they claim I have this water right. Well, it's under protest on it, okay? And the protest has been there for 35 years, but yet they didn't listen to the person that was selling the piece of property didn't tell the people on it.
And
It's
the
under
person who's selling the
protest.
property may not have known about that
And maybe
website
not, maybe
either.
they don't on it.
And that's one reason I was thinking that maybe we should have a notice sent to all the owners, including the empty lots, that this condition exists. Please see state website such and such to find more details.
But see, what I'm saying is it's been under protest, and if these people want to look anything up on it, the water rights, they can look it up, and it'll say a big sign right across the top, protested water rights, okay? And when you got a protested water rights, things can happen within that, okay? On it. So, anyway, now you got the laydown of what happened at Hobble Creek Canyon.
Thank you.
The pipe you're referring to, that would draw water from where?
Well, the nearest source would be Springville City's rights. It's under the shares of the irrigation company, which would be Bartholomew Canyon, to push up that way on it. And there's other sources if you wanted to spend a lot of money, and you could come down the canyon and go under CUP and push water from up there on it. There's other things you can do. You can put in more wells, a big well up there, but you have to have water rights to push wells in on the thing to solve the problems. But there's a lot of criterias with that on the thing with wells on it. And we've been looking at that too, to see about a well and see if that's a source on it. But right now, there is not the water up the canyon, okay?
Thank you.
Hi, my name is Grant Sumption. I am a resident of Springville. I am a property owner in Hobble Creek Canyon. I am the chairman of the Hobble Creek Water Distribution Board. Albert is also a member of that board. That's the board that Ms. Reeb mentioned that she volunteered as the secretary for. And so I'm aware of some of these water right issues. And one of the things that I think you have to be careful of is making a distinction between somebody who has a house, somebody who has a platted subdivision, and somebody who simply has land in the canyon. Because water rights don't depend on any of those distinctions. Your water right does not derive from having a platted lot. Your water right doesn't derive from having a building permit. Your water right doesn't evolve from having constructed a home. And a person who has a priority water right, who's using it to irrigate their pasture, Mr. Harmer's constituents down in Hobble Creek, those guys down there that are putting water on their hay fields or putting them in their cornfields, their water right, if it's earlier in priority, takes priority over somebody who's built a house somewhere. And so to say that you're going to exclude somebody because they're in a platted subdivision and then make the statute apply to someone who is in, just an ordinary piece of ground that hasn't yet been a platted subdivision, that kind of turns water rights on their head. It's not based on whether you're in a platted subdivision. It's based on your priority and putting it to beneficial use. So I think you have to be careful of that. And I think
I don't think
Lambert's,
that was our intent. Our intent is that somebody who already has a water right or a perceived water right in place currently
And they're already
how
a
does
property
this,
owner.
and they're already a property owner,
Whether it's platted or not.
versus somebody that comes in brand new and wants to do something different. So it's kind of like a new development. That was more along the lines as I was.
Yeah, and that's what I thought that you were saying, but then it sounded like Mr. Moore and Mr. Armstrong were talking about limiting it to platted subdivisions, and I thought you were saying anybody who's currently a property owner would be in the same position with their current water right claim, right? Which that's kind of me, right? I don't yet have a platted subdivision, but I've owned property in the canyon since 1994, before there ever was a cottages at Hobble Creek, and my family's owned the property in Hobble Creek Canyon at the very end of the road since 1901. And it never has been and never will be in a platted subdivision, but there's a cabin there and they take water from the springs, and they have for a long time.
You have water rights.
They have a water right claim. I think it's probably protested by Springville Irrigation because they think that it's inadequate or an inferior water right, but that's all part of what's going on in the adjudication. I think the Lambert situation really highlights when this notification needs to happen, and I don't know exactly what the answer is to how you make that happen, but it has to happen before somebody buys the property. It has to happen at that transactional stage to say, all right, if you're gonna buy this property, you need to know about these issues, and you need to know whether or not you have a water right. That's the time to make that information, because if they had known that before they bought the cabin, they could have decided, okay, are we willing to buy this cabin knowing all these issues or not? And if it comes after that fact, and it's the same thing for these folks in the cottages that have bought their lots, it shouldn't matter whether the gentleman has bought the lot but not yet started the building, or has already poured their life savings into it like the Fergusons have. They shouldn't be on different sides of that. They should all know going into it, okay, I've bought this property and these are the issues. The engineer will say that, we're confident in your 13 shares of Hobble Creek irrigation. This other stuff is we're not so confident on, or however that, works out.
How does the county do that?
I think the county can maybe do something at the county recorder's office, some notice that is placed kind of like you do with a special service district, where you put a notice on the on each property in the county or in a particular drainage. I think the part of this statute applies throughout the county, right? Because the adjudication is going on everywhere. Hobble Creek is kind of at the forefront because of where it is in the adjudication process and because of the dire nature of those water rights up there. But so I think one thing you can do is maybe a notice that's on the county records. I wonder if you can require, there's a property disclosure that people sign when they sell a parcel of land. I wonder if there could be some regulation of a requirement for disclosure at that point. I really haven't looked into that. Mr. Moore probably knows what your options are there better than I do, but it does seem like it's at the transactional stage before the building permit stage would be better. But I think they've targeted where they maybe, is it fair to call it low-hanging fruit? It's an area where they can get to because the county has control over issuing building permits. And so that's certainly someplace where they felt like, well, we can at least do this. And I think the challenge is if you start at least doing this, then you start maybe picking winners and losers, and you start to allocate rights associated with water differently than water rights are supposed to be allocated. And so now you're saying, well, you may have a superior water right, but you have a house. And the person with the house gets to use their water in their house, and this person doesn't get to build a house. And that's not how it should be. This person has a superior water right. They should be able to build a house. And I guess the idea is if this person does have a superior water right, he should be able to get an engineer to say so, or a lawyer. And I think part of the problem with that is it probably will end up virtually as a building moratorium until the litigation is done, because the engineer's not going to stick their neck out. They're going to say, well, I'm pretty sure you have a water right, but there's this litigation going on that could change. So I think, I don't know, I didn't mean to take more than a minute, but that's my thoughts on that. I will address quickly the Dude Ranch Reception Center that was mentioned by Carol. My understanding is if it needs a building permit, regardless of the use, if this is passed, then it would have to have the same as a residence. Am I correct? Yeah, anything that is going to use water is going to require it, regardless of whether it's a sand and gravel mine or a house or anything in between.
Okay. All right, thank you. That was our 13.
I did raise my hand, but I don't think you seen it. But
Oh, come up then.
1 minute. I just
Yeah,
want
come on up.
to reiterate that there are 13 water shares in the Hobble Creek well, the Hidden Creek water well, and that they are 1851 priority. There are 48 lots that depend on the water, drinking water, at the minimum, and maybe some green space water would probably be able to serve us to keep fires away from our homes. And so the 48, it's 52 acre feet for 48 families. So whatever the math is that are on that as a solution. We just want to remind about the solution. I also wanted to point out that we haven't had one word from the well owner telling us anything about anything, what's coming, what's happening, what the plans are, if there are any plans. So we're asking for protection from the Springville Irrigation Company, from the county, that those 13 water shares are going to remain in that well and serve the people who have been paying those fees and property owners since the beginning of the development up until now. Because we don't know what's happening. We know there's closed door sessions that nobody can listen to, and they're involved in that with their attorneys, and we just don't know anything about it. And we'd like to. So.
And I'm sure you have contracts in place and so forth, right?
Yeah, we're covered in our CCNRs, which has taken us 4 years. We still don't have our CCNRs to protect us. So we'd like to have that reconsidered pretty soon. And we have the original CCNRs that are intact, and the maintenance agreement as well. So thank you. Thanks for your time. Thanks for your hard work.
Thank you.
It's nobody's fault in this room. It just is what it is. So thank you.
Thank you. All right. We'll close off, at least for now, public comment on this issue. I did ask our health department director to come over. I texted him during the meeting, so if you saw me texting, that was to see if he'd come over here. I had a question. He has not responded. He said he was a little busy earlier. But Commissioner, there's some questions that I have. I think there's one that's an interesting one. If we could maybe look at it a little bit aside from some of the stuff we're doing here, and that's the issue with the building enclosing. I don't see that necessarily as totally tied to the water issue, just because as they're trying to enclose their structure, they still, if the water issue is, they could still use it as a cabin, as they demonstrated. As they said, they could just go up there and stay. I'm trying to find a way, and I'd need some advice on this, because I don't know what we could do as commissioners on this to at least allow them to enclose, we'll call it their cabin, without water or whatever. However, what could we do? What's the possibilities? Because I wanted to have Eric come over. I know it's probably sitting at the health department, but they're probably tag teaming back and forth. And I realize and I recognize that we have a pending ordinance change in place as we're going through this process, but I'm just wondering what the possibilities are.
Commissioner, sorry, this is Ben Van Noy with the Attorney's Office. If there's any questions you have with the Health Department, I may be able to answer them at this time if you want.
All right, thank you. Thanks for being on there.
It may come up while Bryce is talking through this.
So, yeah, we've explored this also. That the challenge is this pending ordinance statute. we did meet with the owners after the meeting last Wednesday and said, well, if you can meet the ordinance as it's proposed, then we could release it immediately, which was somewhat of a compromise.
I just have to, this sidebars are probably not appropriate for an open and public meeting, so let's try to keep them.
So the other thought is if you do feel like you need to continue it, subject to some of these provisions being worked out, then the interpretation would be, well, if a submitted permit can meet those requirements as proposed to be amended, then we could look at perhaps that. I'd have to talk with the attorney's office to see if that's something we could just release. So in this case, they meet those exceptions that you want to work out, the wording on. They can show they can meet those. Then that might be a way to look at a release of the permit.
Right away? Is that?
Yeah, let me add one more thing on that. We have in the past allowed, if a structure is open, we have allowed them to come in and shore that up. So I think that happened in Vivian Park a couple of years ago, where we had a structure, something was pending, I think it was an ordinance that they had proposed was pending, and they had a structure that was open and had animals getting in and things like that, and we did allow them to close that structure up. And
Even though you had a pending ordinance that was
because it was
being
a
looked at.
safety issue, became a safety issue.
Yes.
And so that's why we looked at it that way.
Okay.
It's a humanity concern there.
So as a safety issue, we possibly could do that. So, yeah, we can discuss doing that.
I apologize, but he was saying, the owner was saying that theirs is not a health department issue, it's more just to close up the house, the cabin.
Right.
So that might be an answer. Let me just mention one other thing, if I might, since I'm up here anyway. You had talked about the waiver and release. We've heard a lot about that today. If you want me to go over that with you in this meeting, I'm happy to do that. Basically, we could look to modify that. The language of the ordinance, all it says is a waiver that's approved by the county attorney's office. And so, I mean, that's not set in stone either. That's something that we can discuss. Basically, the waiver in its current form just says that you're on notice and you're at your own risk based upon the litigation. And number two, this is the meat and potatoes of it, 1, 2, and 3. And I have copies for you that it's also attached to your agenda as well. Number two, it says that basically puts people on notice that they release the county. If you're going to build at your own peril, then you're also going to release the county who is telling you there's a water issue.
Yeah.
So that's number two.
So Rob, I wonder if can we deal with this issue first though, and then come back to this?
Absolutely.
So Commissioner,
Yeah.
And it looks like you want to speak to it to a certain extent. So come on forward and we're trying to find a way that you can enclose this
I know,
before
and
the
I
winter.
appreciate it so much. Last week, my builder and I went to Mr. Armstrong's office, and he asked if they would just give us the 4-point inspection, which is like a partial thing, just so that we could close it in, and he said no.
Okay, and
That's all we asked for,
Yeah, we've
just to
already
close
asked.
it in.
and he's doing what he needs to do, and that
I
is because of
understand
what's
that.
going on. We're trying to find a way.
I
that
understand that, and I do appreciate it.
Okay.
And as far as the health department goes, we're completely, like I said, our permit is
Okay.
completely approved.
So-
They just won't give it to us
because
because we have, because of this waiver, because of the
So, but it
proposed
has
amendment.
nothing to do, because now Eric just told me he's on his way, so he may be going over here for no
Yeah,
reason.
yeah.
But I was assuming that the health department was holding up your building
No.
permit to close it in. But they're
Holding up the whole permit until I sign this waiver that my attorneys
And
have
have
said do
the,
not sign, and have the engineer
engineering
sign.
document.
and have the engineering document. So
And so
we could
until I do those
proceed-
two things, they will not give it to me.
we could proceed to go through, I mean, a 4-way inspection doesn't necessarily mean that you can put the roof on, but what are you gonna do? Just put tar paper down for the winter time, or shingle it, or what?
Right now, it just has
That's-
house wrap on the roof, and then
Yeah.
everything else, windows, doors are open.
I'm afraid by next spring, the deck's gonna be in my kitchen.
Yeah. So there's a way, like we talked about, that this can be, that you can go ahead and enclose it all in, make it a shell basically as it's worked through. And of course, if things get resolved, so that you can then go up there, snowmobiles or whatever, and work on it in the wintertime. Is that,
Yeah,
am I
you
hearing
can't
this
work
right?
on it in the
Yeah, in
winter.
the
There's
wintertime, it
there's snow
closes
getting
down.
up there in the winter.
We have
So
a small window from about May
Yeah.
to October.
Okay.
yeah,
Thank you.
that's all. Thank you.
Thank you.
Bryce Armstrong, staff. Yeah, I did meet with them, and I actually didn't tell them no right there. I said I would see what options we had to see if we could get to four-way in talking with the attorney's office. And then the answer was if they can comply with the proposal as proposed, we could do that. So I did try and stretch that as much as I could.
Sorry, Eric. I was trying to text you. I think we got it worked out. We had some confusions on permits and so forth. And so thanks for getting your steps in and coming over. Your health department example right there. But we got it. Thank you.
Usually in these situations, we look at potential that, hey, can we get the concrete down? Or this project doesn't involve a whole lot of concrete. It's more building above existing areas. So really the logical area to kind of say, let's get you to this point would be the four-way. And so I told them that I would pursue that and got back to them the day after. So
Okay.
to let them know that we could under these circumstances. And so if we could take that same approach, if we're going to scale back some of those requirements, and then they wouldn't be required to do the engineer statement. That's what I'm hearing. So.
Right. And that's however we go. But are you fine with that?
No,
Commissioner?
that was exactly what I was going to bring up if you didn't. But yeah, I'd like to see them be able to close it up, seal it, so it doesn't is not intruded by
As
creatures
would
or
we.
weather.
I mean, believe me, we really were looking at
Okay.
options to see what we can do.
Yeah, I would say let's grandfather them in, let them complete this before the season's ended.
So I don't know what needs to be done there, but we're probably assuming that that's going to be taken care of then. That will work. Now, back to...
No, and on that,
this.
just to add this little clarification, I wasn't aware till today that it was actually open. We were talking about foundation last week because then we realized they didn't need foundation. It was all interior work that was being done, but I didn't know there was actually open portions of the structure until today. So that's why the thought came that we've dealt with that in a health safety manner before and trying to make sure we can secure the building.
What is there anything we need to motion
No, I
or
think
anything like
no,
that?
I don't think so. I think
So
we've
you're
got
good to
direction.
get
We've
this
already
going?
told you we're
So
moving
you
forward
can
on that.
schedule it before they leave then?
Yeah, we can take care of that.
All right. Can I
Please.
So a couple of things I wanted to clarify as we're working through this, and this process is always a messy process because our form of government allows for a lot of conversation, and that's the beauty behind it. It's also messy because there's a lot of opinions and there's a lot of things involved, and we're talking about people's lives and their property, and we feel them, we know them as well, and so I'm concerned that. Well, I shouldn't be concerned. I just want to acknowledge that as we're going through these processes, that it does go up and down, and there's understand. We are, as commissioners, we are only as good as the information that we have, and if the information comes, hopefully, if the information comes good to us, then hopefully we'll make good decisions. And so we appreciate everyone coming in and giving us feedback on it, and we have our own processes that we work through. But it is messy. There's a couple of things that I see, and Commissioner, please chime in at any time from yours. The reason why the commission sent this, to the Planning Commission, is because we recognized a few things. One, this litigation has been going on for a long time, and it makes us nervous that. Because this litigation is going on water, it is assumed, and it seems to bear out that it's been over allocated in the way of water, and because of that, it puts us in a pause pattern to try to figure out what can we do, what should we do. Just because government can do it doesn't mean that we should be doing it, and we're trying to find that balance. That's where it gets messy. And so what we do on that is we send it to the Planning Commission, which is a whole different group of individuals who look down through it, do some work with staff, and come with proposals, to us on, a first brush of what is out there. We recognize and realize that there's going to be further conversation, details, and more specific. And there's probably some areas where we're trying to look into the future and we just can't. We don't have crystal balls. We're just trying to figure out what would work and work well. And we also probably realize that there's going to be upset people on both sides, one way or the other. But the one thing that always gets me with this issue is, where's the county's responsibility when it comes down to the water issue? And I'm not solid on that. I'll just admit it. I'm trying to find my way on where that's at. I do recognize, and I've been told by the state engineer, I've been told by our county attorneys, I've been told by water masters that we're over allocated. No one wants to run out of water. And if we have more water in one area, like the gentleman here says he has more water, and then, can the county go back to the state and say, hey, let's have negotiations? Then, are we becoming a party to something that we've never really done before? I mean, it becomes really interesting on how those dynamics work. And so in looking down through this, as you can see, we've had questions on it. We're worried about how it works on a practical basis on the ground when things happen. And we're trying to find our way with it. I would anticipate that we're not going to come to a conclusion on this today. I just don't know how that happens. I don't know if you feel differently, Commissioner.
Yeah,
but
when this first came up, Commissioner Lee, it was January, I think. I had just begun.
Yeah.
If I'm not missing anything. And we had no idea that this was an issue until January this year. And so we've been trying to methodically, as well as we can, to come up with a solution, because we are concerned for those that are buying lots with the intention of building, or buying lots with the intention of building a home later on. And what about those who already live there? And then the word shut off is alarm. And that's why I keep asking, is there like a graduated scale that they reduce the flow? Or is it just simply one day it's there and one day it's not there? So there's a lot of unanswered questions. And what I'd like to do is follow up with the state and have a meeting with them separately and go through this process. It's been open and public for a long time, but we need a little bit more detail, perhaps with the state separately.
And I would suggest, Commissioner, that you meet with the River Commissioner. When he was here in the Planning Commission a few months back, I think he talked about the very shut-off thing you're mentioning. And so he could probably tell you how that would look, because he did give that information to the Planning Commission, how it might look as a shut-off, that he'd be the one doing it, and how that might work. So
Well, we'll follow up after this is all finished, and maybe we can look at me meeting with those individuals and bringing them together, perhaps as a administrative dialogue.
And let me kind of say, Commissioner, I think you've hit it correctly. It's a balance issue, because you've heard here today in this very meeting where some folks have said no permits, don't do anything. You shouldn't allow anything in that canyon.
Right.
And you've heard others who said you shouldn't do anything to stop anything either. So what you're trying to do is to balance what should you be doing on this to try to address an issue that again was put in your lap, and how to protect your citizens up that canyon, and the whole county, but up in that canyon particularly.
Yeah, and technically, the county is more of an extension of the state by providing record keeping and security for the people that live here. So I'm trying to, that's that balance piece, yeah.
But if you're going to continue it, then I'm happy to sit down with you as well if you want to discuss the waiver and any concerns you might have. Part of my job as the county attorney, in the county attorney's office, deputy county attorney, is to help try to protect the county as a whole. And there's some merit to that, right? Because if someone is going to build knowing that they might have inferior water rights, then they ought to not sue the county afterwards when they lose those water rights.
Yeah. And I think, and I read down through this letter that was sent out, water rights declaration, disclaimer, waivers, and releases with declarant covenants, conditions, and restrictions. And I forgot who gave this to me. Somebody gave it to me. I would probably recommend that we don't send any of these out until we resolve the situation. I think I read down through this and I can see where it would cause a lot of anxiety.
Sure.
Until we've actually got some conclusions to it. I can tell you, and I get a sense, Commissioner, that we're probably going to continue this for more. And I can tell you what I will do in the meantime, continue to have conversations. There was a few solutions that I'd like to chase. And I don't even know, I mean, this has been going on for 40 years plus whatever in litigation. And so, and I don't mind having the conversations with the state and whoever else on, is there a possibility for the 1.2, 1.3, whatever it is, a little more. And we're talking about one area, and I realize this is a bigger area, but sometimes you take things off in little chunks. But I also realize that in the county we have ordinances in place that probably have more water on there, which means there might have to be a change in place. So I'm not trying to think that I can wave any kind of magic wand and this thing all of a sudden goes away. It's been going on for 40 years on the way of that argument. But I can commit that I'll have those conversations to see if there's possibility for it, and at least run down that road and chase it to see if there's a solution to it, at least for a section. And I think that will at least give me more information on where we're at with a portion of this.
Ross Hansen called it a haircut. That's what we would.
Right.
It would be a haircut.
And I'm really sensitive to individuals who've been paying all these years and just a certain extent for water rights, and then all of a sudden there's a haircut that comes in there, and is that a taking? I mean, it becomes all those issues. If there's a whole bunch of agreement, which I haven't seen yet, but if there's a whole bunch of agreement that comes in there, I think we can probably get more done than a whole bunch of fight. But it's an issue that's been going on for a long time, and so I feel that if we don't try to work together with it somehow, that what will happen is that we'll just be told this is what's going to happen, and that's it, period. And I don't think that the county has a lot to do with that. I think that that the river commissioner and the state will come in and say, here it is, and that's the way we're going to have to follow.
If we continue this, we need to talk to the state before we bring it back, so we have some answers from the state and we can provide to the public as well. So
Absolutely.
I'm concerned about if we make it only a week away or 2 weeks away, we might need to push it out a little bit longer.
You could schedule it for a work session and ask the state to come down to the work session and provide any additional information you'd like. That would be an option.
Just one thing to be aware of, Commissioners, is you started this whole process
I know.
in April. And by state law, it's considered a pending ordinance for 6 months. You're welcome to go past that. If you go past that, the pending ordinance part will stop, essentially. So anybody who applies would no longer be subject to what you have pending. Now that's, I don't remember the exact date, but I think it's
It'd be the
October.
end of
It's in
October sometime,
Yeah,
I
it's
guess.
near the end of October. But just be aware of that. But again, that may not be an issue. You may say that we don't care if people are subject to the ordinance. Currently, the state statute does make people subject to it for the first 180 days. And then if you go past that, then they're no longer subject to this. And then after it's passed, then, assuming it is, whatever version's passed, then those who come in afterwards will be subject to it.
What I'd like to do is have maybe an informal work session with the state that's not necessarily public, but just to come up and iron out some answers so we can go to the public and have more of a free dialogue and do that.
We probably have to do that one-on-one.
Right.
Yeah. I mean, we can have conversations one-on-one with the state engineer
meet with
and
them
others.
as a group without deciding. I thought the law was allowing at least two could visit without coming to a conclusion.
No. There's a legal exception for a definition of a quorum, but that requires not more than two commissioners and no other persons can be present. It's limited to just those two.
What if it's more of a dialogue, understanding,
matter.
perception?
Individually, you could do that all you'd like.
We can't, the
We could
two of
schedule a
us or
work
three
session.
of us meet just without any, we could have you there as babysitting us, making sure we didn't do anything
Wouldn't help.
incorrect. So one-on-one then, okay.
Thank you, Commissioners.
Okay. I'll make a recommendation that we continue this to the 27th
Of October.
October. If that works for you.
That gives us a full month. What's going on? Let's see. 27th, we have, that's it so far. You
And,
know,
you know, it might be a good idea to have the work session, and we could do a work session at the beginning of the meeting and have the agenda item, if we want, on the 27th in the regular session, so that we can, you know, have more dialogue with the work session and always our preliminary discussions. Uh-oh, maybe that's not
Oh,
right.
no, just to tell you that October 28th will be when the pending ordinance would expire. That's the 180 days.
Okay, so we'd be a day before that if
just so you
if
know.
anything was done on that.
yeah, if we did the work session that same day and then come back to after the session, the work session will iron out any misunderstandings. Would it provide?
Well, I think what the work session would give is that it would give us as commissioners an opportunity to talk about what we've found along the way, and then we could kind of get a sense for where we're at, and then in the regular session is where we'd make decisions if we wanted to, or if we don't, then then it expires on the 28th.
If it's that close, should we have a work session the week before the 20th and then iron that out? If necessary, have a second work session on 27th. If
We
there's
could do that
confusion.
too. I was just trying to give sufficient time
Yeah. So,
to meet.
because there's so many unknowns with this. I don't know if it can do it in one work session. But if we meet with the state individually, and with you there, Bryce, we could get some more depth.
Sorry, Bryce, again, as Mr. Moore stated, that's not a hard deadline. That's just when the pending ordinance. So if we need to go past, then quite honestly, it makes my job easier. We'll just, administer the ordinance as it exists until something new comes up. But so, if you find need to, we can just do the work session on the 28th and, do
Vote
it
on it a
later.
week later, perhaps.
Yeah, I mean, don't feel like you have to rush it, I guess.
Yeah, because I just want to make sure we have a thorough enough research and have the time to do that, and be able to get those individuals here. Okay, let's just shoot for the 28th and do a work
27th.
session. We could put an agenda item to approve or deny that concept then, but we could also strike it and move it another week.
So we can put it both on work session and on the 27th
27th of October,
of October. Yeah,
with the possibility going into the 3rd of November
if
then.
needed.
Okay. That works. But lastly, making sure this family is taken care of, they can close out their house, their cabin, I mean.
I think they're good.
We're good with that, Bryce? For this family closing up their cabin? Thank you.
Okay, so a motion then would be in order on that.
I'll make a motion that we continue item number 23 to October 28th.
It's 27th.
27th. That would be Wednesday, not Thursday, at 2 p.m.
And we'll put on the agenda.
A work
is the motion
session.
Include both a work session,
Work session
and
and
an
a regular
agenda.
agenda item.
On the same day, work session first. Okay.
That's my motion.
And I'll second that. All in favor, say aye.
Aye.
Aye. That passes 2-0. Okay. That is the end of our regular agenda, except for our closed meetings. And so thank you for being here today.